Your Lordship, item number 47 is on behalf of now we kindly let the letter come up after 2 weeks, Your Lordship.
Yes, Mr. City. Any objection?
No.
Okay. MSAME, the Learned Council makes a mention on behalf of MS Inaholi, the Learned Government Advocate, and seeks adjournment of the case for 2 weeks. Prayer is allowed, listed accordingly.
Lordship, Lordship.
Yes.
So Lordship, above mentioned hearing item number 44.
Ah. MS Asarutsa, Learned Council, makes a mention on behalf of Mr. City Jamil, Learned Senior Council, and seeks adjournment of the case for 2 weeks. Prayer is allowed, listed accordingly.
For motion, item number 1.
What is the petition, Mr. Panki Richabo?
This is
Yes.
Honorable Court, fight order dated 6/9/2024, directed me to file, IA to give for amendment of the post title in order to give the proper title of the respondent number 4, 5, 6, and 7.
4, 5, 6, and 7.
So,
Your prayer is Only in respect of on respect of all the respondents.
For 4 to 7. My lord, page 11 and extra 3. There's one number 2, I provided the change address. There's one number 4 on annexer on page 11, annexer 3. On page 12, the respondent number 2 have provided all the address. The 4 respondent.
Where is your page 12? Just give him this page. Let us see whether there is some page 11. Just give him. Okay. Which is the correct address of the respondents?
Yes, my lord.
No, which is the correct? Oh, you have not stated in your petition. The correct address to be amended in the course title is given in page 12, annexure 4 of the application as follows. Madam? Page 12, annexure 4. Okay, A, B, C. The application praying for amendment of the course title in the connected writ petition is accordingly allowed. The application stands disposed. In the main writ petition, in view of the order passed in ISC 170/2024, the correct address of the respondent number 4 to 7 shall be incorporated accordingly. Okay, 4 to 7. Okay, registry, we take steps. Yes, when is this fixed? Listed after 3 weeks,
4 is more.
after 4 weeks. Okay.
For motion item number 2.
Yes, ma'am.
That is lordship.
Yes.
Through this application, petition lordship, the petitioners are including the regulation dated 15/9/2008.
Where is that regulation?
Lordship is in petition number 27, and the translation is from page 28 to 29.
38.
Your Lordship, this regulation has violated certain it's a regulation and regulation.
which was forwarded to the Director, Department of Social Welfare, Nagaland, Kohima, by the District Planning Officer, Tuingsong, by later dated 4/7/2017. So however, despite the application submitted by the petitioner, which was forwarded by the District Welfare Officer, Tuingsong, no action has been taken by the government to appoint the petitioner on conditional employment. Stop. Being agreed, the petitioner is before this court. Stop. Issue notice to the respondents, returnable after 4 weeks. All the respondents, MSAIME accepts notice on behalf of all the respondents and therefore no formal notice need be issued. Stop. The Learned Counsel for the petitioner shall however serve the requisite copies of the writ petition to the Learned Government Advocate within
3 days.
a period of 3 days.
For motion item number 4.
Here's the same prayer, my lord.
Same,
Yes, same prayer, your lordship, compassionate upon.
same post,
Uh,
same date of death.
no, your lordship,
Huh?
different, your lordship, but prayer is same, my lord.
Okay, the line petitioner, husband died in harness on 27/12/2023 while serving as the driver under the establishment of the executive engineer, PWD within Brigade Housing, Division 1, Kohima, Nagaland. On the representation, the petitioner has accordingly submitted the representation dated 1/4/2024 and 1/8/2022 to the representation to the
The chief
chief
engineer,
engineer, to the chief engineer,
NPW.
housing, NPWD, and the executive and the engineer in chief, NPWD, Nagaland, Kohima. However, as the respondents have not considered the application submitted by the petitioner for completion at the point, the present petition has been filed. Okay, just that modification. Okay.
Obliged, my lord.
For motion item number 5.
Yes, ma'am.
Yeah, please, lordship. Your lordship, in view of the complaint and the registration of the criminal case, I was suspended on 31/7/2018 and subsequently by order dated.
By which order? By which order you were suspended?
And it shall be page 40. Subsequently by order dated 13/3/2020, page 16, I was reinstated in service.
By page,
Page 16. I need you to see page 16. And in the meantime, I was.
13/3/2020 is the reinstatement order.
Yes, Your Lordship.
And you were seeking for a direction to quash and set aside the reinstatement order also.
Your Lordship, in the reinstatement order, it is being said that I'm imposed the penalty of withholding of increments for 2 years with cumulative effect. So I'm asking, so I submitted a representation to the authorities to review my reinstatement order, Your Lordship.
So if your reinstatement is quashed and set aside, you are no longer in service. That is the logical conclusion. Anyhow. Who is leading you in this case?
What did
Mr.
you mean?
Wati. Just take care of your, just
I'm
take
not
care of
challenging
your.
the entire reinstatement order, Lordship.
Ah,
The only part by which penalty has been
where was it?
imposed
Okay, have Mr.
and the bail here has been denied, Lordship. Only that part.
MS so and so. Learned counsel for the petitioner. We are reflecting your junior's name. Okay, in the order. Learned counsel for the petitioner. MS so and so, then counsel. You are serving as a NCE.
Yes, Your Lordship.
NCE, what is NCE?
Uh, non-competent employee.
Non-competent, okay, the stop. That is MS so and so, then counsel for the petitioner. The petitioner is presently serving as NCE under the police department and attached to PHQ, Nagaland, Kohima. Consequent to the registration of a criminal case against the petitioner. The commandant was NAP, Chomogidima, Nagaland, issued the order dated 37/2018.
31/7.
31, okay, 31/7/2018, placing the petitioner under suspension. So the petitioner was however reinstated in service by the order dated 13/3/2020, passed by the Director General of Police, Nagaland, Kohima. So in the reinstatement order, it was however provided that the petitioner shall not be entitled to pay allowances during the period of suspension till reinstatement in service. But the service was to be counted without break for pensionary benefits. Stop. Consequent to the order of reinstatement in service, the petitioner was discharged from the criminal liability of the case by the Learned Judicial Magistrate First Class Kohima, Nagaland, by order dated 30/4/2024. It is the case of the petitioner that since he has been absolved from the criminal liability of the case, the petitioner is entitled to the full pay and salary during the period of suspension. So issue notice to the respondents returnable in 4 weeks time. Mr. E. Chiba, home, the learned government advocate accepts notice on behalf of
All the respondents.
all the respondents. Therefore, no formal notice will be issued. The learned counsel for the petitioner shall however serve the requisite copies of the writ petition to the learned government advocate within
3 days.
a period of 3 days from today.
For motion item number 6.
Your lordship, the facts are same. Yes, except the suspension order date,
Suspension order.
yes, your lordship.
And this petitioner is serving
As constable driver,
yes. Okay, ma'am, take note of that. This petitioner is serving as
constable driver,
constable driver. As police constable. Police department, correct? In the police department, Nagaland, correct?
yes, your lordship.
Then
Here the suspension order that it is 2/10/2018,
suspension order,
page 13, MHRD.
suspension order is dated 2/10/2018, passed by Assistant Inspector General of Police within bracket administration, correct?
Yes, your lordship.
Then what is the difference, particulars, any difference?
No, your lordship.
Same, by the same order passed by the court,
Yes, your lordship.
same representation?
Yes, your lordship. And same period.
Same.
Yes,
Okay, same.
yes, all the rest.
Much obliged.
Much obliged. From the supplementary cost list for motion item number 54.
Here, Mr. Cynthia,
May it please, Madam Lordship. The central as well as the state government has taken a decision, Lordship, to relocate the construction of a multipurpose hall from Monsimdi to my village, that is Chakpa village, Lordship, under the Ministry of Tribal Affairs, under the plan in provided under Article 275, sub-clause 1 of the Constitution of India, Lordship. On the ground that, Lordship, there is already another multipurpose hall at Monsimdi village, which is already completed and it is under utilization, Lordship. I have annexed a photograph of that at page 19 of my interlocutory application, Lordship. Now, Lordship, after I filed the petition, the IA, Lordship, it has been reliably learned that there is another multipurpose hall which is funded by a different ministry, Lordship, already completed and constructed it.
no, Mr. Cynthia, why do you want to impede yourself?
Yes, Lordship. Now, the petitioner in petition 219/2024, before this honorable court, they are aggrieved by the decision made by the central as well as the state government to relocate the construction of the multipurpose hall from their village to my village, Lordship. Whereas I have not been made a party in the petition, Lordship. So, in my humble opinion, Lordship, I deserve to be included as a necessary party in this instant case, Lordship, because without my presence, Lordship, I believe that any legal order, Lordship, can be passed, Lordship. Because obviously it is going to adversely affect my rights.
What's the difficulty?
There is no difficulty so far as I am concerned, but the grievance of the writ petitioner is we are aggrieved by the decision taken by the Government of India and the State of Nagaland. That is how we are aggrieved. So we are challenging their action only. That's why.
Like, the applicant is agreed because actually like,
Yes, due to the illegal decision of the Union of India and the State of Nagaland, they were become a beneficiary. And if at all they want to be embedded, I have no objection. I leave it to your lordship and let them file a short affidavit. But lordship, my only prayer is, since it is a public development, let a short notice be issued. And in the meantime, the status quo may be maintained, lordship, in the main case. So far as embellishment is concerned, I have no objection. lordship.
No, Lordship. No,
It is not there.
Lordship. May it please your Lordship. For September 2024, this letter was listed, clarifying the position, how the relocation was taken place. So accordingly, I have placed the official letter which I have received from the. Yes, yes. I may be granted 3 weeks time. to file my affidavit. Since I received these, Lordship, please service copy only on last Friday. Can be my Lordship as the.
No, we'll list it and then we'll make an observation that then endeavor shall be made to dispose the.
Yes, yes. Since you can release it immediately after Diwali, Lordship.
Why Diwali is so important for you?
Because Lordship, we can work during the holidays, Lordship, of the craft.
Lordship, I am declaring 3 weeks time to file my.
The multipurpose is now located in your village or in his village,
In my village.
in your village.
Yes, it has.
And Mr. City, your case is that it has been illegally relocated.
Correct. Lordship.
So we allow this application for implement.
Lordship.
Mr. City, what is your grounds for implement? Where have you stated? Your grounds for implement?
Paragraph, Lordship,
Ah,
6 and 7. 5, 6 and 7 in fact.
what about four? Four also?
Yes, sir.
Mr. Santiago. The Lieutenant Counsel for the applicant. The present application has been filed. Under Order 1, Rule 10, Clause 2 of the Civil Procedure Code 1908, praying for improvement of the applicant in the writ petition number 219/2024. Stop. The reason stated for the reason stated for improvement is projected in paragraph 4, 5, 6, and 7 of the application. So this court on perusal of the application is satisfied. The petitioner has been able to satisfy this court as to why the applicant should be included as a party respondent in the connected writ petition 219/2024. Stop. Even otherwise, Mr. C.T. Jamil, the then senior counsel for the opposite party respondent number,
Writ petitioner.
opposite party with petitioner,
Yes.
has no objection to the application or improvement of the applicant as a necessary party in the connected writ petition. The application for improvement of the applicant as
Respondent number 4.
as respondent number 4 is accordingly allowed. The application stands disposed. In the main writ petition, in view of the order passed in IAC 171/2024. The applicant in the IA is accordingly included as the responding before in the writ petition. The, have you received the copies? You have not, have you received the requisite copies? That's it.
We have already served the copies, Lordship.
I received on last week.
Okay, so you file your affidavit?
You send it, I will serve the copy, Lord, since he's leaving on it today.
No, I'm asking about something.
Yes, we'll serve it in the course of the day.
The learned counsel for the petitioner shall serve the requisite copies of the writ petition to the newly included respondent in the course of the day.
Lordship.
Mr. Senthiyanger, Mr. L.T. Sankam, the learned additional advocate general, as well as Mr. Senthiyanger, the learned counsel for the newly included respondent, shall file their affidavit within a period of 2 weeks. Within a period of 2 weeks from today, and an endeavor shall be made to dispose the writ petition on the next returnable date listed on. Can you have a date?
For 5th of November. 4th is a Monday.
Yes. Listed on 5th.
Lordship.
Yes, you enjoy your puja and then you come. Listed on 5/11/20.
Certain status quo may be maintained.
Lordship, that will not be beneficial to either the petitioner or me. No, whether actually the multi-purpose has been.
No, nothing has been done yet. Actually, after the decision is taken by the government, they have to send the PPR.
Yes, Lordship. So much needs to be done.
So many procedures are required to be done. Actually, that should have been done before a decision is taken to relocate. That is why I'm submitting that it is putting the cart before the horse. Actually, they should have prepared. Lordship is well aware how a DBR is proposed and then approved by the state and in the central level. But without doing all this, they have just taken a decision to relocate.
Where is that order? Where is that order to relocate?
Your Lordship, there is already one multipurpose building at Muslim. So again, another multipurpose building is proposed to be constructed in the same place.
We are not
In the guideline, there is nothing of that sort.
We are not passing any adverse order. Any adverse order, because actually since the multipurpose has not been relocated. We are saying, okay, let it remain as it is. Still the matter is heard on that. Yes, I think, no, we are not passing any.
Subject to the outcome of this.
Okay, that is also. Yes, okay.
Yes. You know, we not install the decision making process at the government
So
level.
what is the relocation of the
Relocation of multipurpose hall
multipurpose hall at?
from OCMT to.
Let us see that order, that's what I'm saying.
Yes,
What
Lordship.
is that order?
Page 59.
Page 59. Page 59. So,
This is the letter from the ministry.
where is that particular word, relocation? So we put,
No. Right. 1 week.
Yes.
For motion item number 55.
Okay.
The present they are agreed by a decision given by the state cabinet.
Ah.
The cabinet decision is page number 144. Annexure. This decision began on 6 August 2024. Regularization of service of COVID-19 appointees through the Public Screening Committee in relaxation of earlier approved position. What happened was.
What is the background behind this cabinet decision?
The background is like this. Several medical officers they were appointed during the COVID time.
Ah.
The state government they have formulated a policy to regularize this COVID-19 appointees by a special recruitment drive. And that you have to frame the policy to extend some relaxation to those increase. That policy was forwarded to the Nagaland Public Service Commission. However, Nagaland Public Service Commission refused to entertain the proposal submitted by the department, saying that the examination has to be conducted only as per the regulation.
As per the
Regulation, the NBC regulation. So thereafter, again, the department submitted another cabinet memo. And the cabinet memo was to regularize those COVID-19 appointees through the Department Screening Committee, which is approved by this impune cabinet manager. The post of medical officers. Now we are concerned with the post of medical officers. This is covered by the Nagaland Health Service Rule 2006. As per the Nagaland Health Service Rule.
let us see that rules, whether you have enclosed. Okay. Yes, which rule?
Rule 5.
Rule 5.
Classification and grade of posts. Now we are concerned with the
Classification and grade of post.
now we are concerned with the grade 6, clause 6, junior grade.
Junior grade.
Junior grade it consists of medical officers, junior specialized, junior dental surgeon, and equivalent posts or posts that may be declared, made from time to time by the government.
How was the recruitment to be made?
Yes,
Which rule?
so it may come to schedule 2. This is schedule 2 as we
Mr.
play in.
Rule 7. Rule 7.
Yes, in consonance with rule 7.
Mr. Lima,
Yes, Lucy.
rule 7, correct?
Yes, rule 7. Lucy.
The method of,
Method of recruitment.
be made by either of by promotion in accordance, by direct recruitment in accordance with rule 8.
Clause 3 is important. The respective quotas reserved for direct recruitment and for promotion, the qualification and other conditions required for promotion from lower grade to higher grade, in the qualification required for direct recruitment shall be as specified in schedule 2. We can come to schedule 2. That is at page number 20. Page number 20. Now we are starting with clause 6. Junior grade. This is a 100% direct recruitment post. In the qualification is the post shall be filled by direct recruitment. The minimum qualification for direct recruitment shall be MBBS or equivalent degree of a recognized university.
Let's see the classification.
The classification on clause 5. Rule 5.
Any power given for relaxation of the rules?
Rule is signed.
Yes, madam, without any relaxation in the rules, how do you propose to conduct this special recruitment drive?
Well aware,
Lordship, we have to see the events. Your Lordship, during the COVID pandemic situation, your Lordship, which is unprecedented.
No,
where-
that we know, but if at all that a special concession had to be given for those doctors, then immediately you could have amended the rules as a one-time measure.
It was as one time, because of litigation after litigation, your Lordship, it has been dragged on, your Lordship. And initially it was to be conducted by
Yes,
the
okay,
NPSC,
well,
Lordship.
let us let the petitioner first satisfy his case.
should be pursuant to the cabinet approval, we should become the page number 145. This is a letter written by the state government to the principal director, County Interim.
This is impugned.
Should the next, the subsequent orders indeed, the subsequent letter. This is only a direction to make the necessary arrangement. This has been complied. This is a letter dated 20th August 2024. With reference to your letter number so and so, dated 9 August 2024, and on the subject cited above, it is approved by the state cabinet by cabinet number so and so, dated 7 August 2024. I am directed to convey the approval of the government to conduct written exam and voice of one-time dispensation of special recruitment drive of the specific categories, 280 posts of the engaged persons. It is a command order. Necessary arrangement may be made for conduct of the exam in free and fair manner at the earliest. Date of written exam was fixed on 26 August 2024. Date of waiver was fixed on 27.
So by this letter, there was only a specific category of employees who were supposed to be recruited through
Special
special
recruitment.
recruitment drive.
And Lordship, subsequent to this leader, this leader is in due.
Just let me properly read this 145. As approved by the state cabinet by Central, I am directed to convey the approval of the government to conduct written examination and viva voce of one-time dispensation of special recruitment drive of specific categories. Necessary arrangements. The 280 was okay. Okay. So next,
Lordship, this 280 posts it consists of the staff nurse, the dental doctors, Now we're concerned only with 98 posts of medical officers. In this
98 posts.
posts of medical officers.
98 posts to be recruited through
Special
special
recruitment
recruitment drive.
That is under challenge, Your Lordship. We're challenging that. Lordship, we come to the next page. This leader is in due.
This is a letter issued by the principal director.
Principal director to the chief medical officers in the superintendent of all the district in the state. Lordship, may kindly see this. Sir, please find here with a list of doctors allopathy for special recruitment drive and annexure 1. Annexure 1, Lordship, that we are challenging. Chief medical officers, medical superintendent, controlling officers are requested to inform the doctors in the list to submit a form through a mail to so on or before 22/8/2024. The applicant will collect admit card personally at Directorate ECRD seal ISTB conference hall on 23/8/2024, Friday and so. Doctors whose name is not included in the list need not apply. By this clause, we are totally parked. Only the listed doctors, they have to appear in the special recruitment drive. Lordship.
So this has been conducted.
No, Lordship. Lordship, it was proposed to be conducted from 26th of August. Lordship, there was a serious opposition to this special recruitment drive. After the department by a letter,
No,
yes,
Mr. Lima,
Lordship. Yes, Lordship.
kindly clarify.
Hmm.
What is 146, page 146? This is what? This is, what is this? This is information or what?
Lordship, this is in continuation of this letter, page number 146, 20th August. It was issued on the same day. By this letter, page number 145, the principal director was directed to make the necessary arrangement for conducting the exam.
Let's see the annexures.
Lordship, the next year, Lordship, this, Lordship was, page number 153. Lordship, by this letter, they have deferred the
One-
exam, 153.
No. Where is the name of the 98 doctors?
Yes, Lordship, 98 doctors. Lordship, it's start from page number 147.
Oh.
This is the list. And Lordship, there's another interesting issue in this list.
What is that interesting issue?
Page serial number 1 to 9. They are not a COVID appointee. They were appointed on contract basis during the period 2012 to 13. On earlier occasion also, they approached this honorable court, bring for a direction to consider the case for regularization as per the scheme of 2006 and 2008 framed by the state government. This honorable court has not granted any relief to them. Again, now the department is proposing to regularize your service by clapping up your case with the COVID-19. That is an exercise which is being carried out in the department. Serial number 1 to 9. I have annexed the order passed by this honorable court as well, on earlier occasion.
So this 98 doctors are the favored few,
The selected one, the chosen one.
the chosen one. 90.
Actually, Lordship is well aware. When the role has been framed under Article 309, the seat statutory role, it cannot be supplemented by an executive decision, which is done in the present case.
What is your representation? This,
Yes, Lordship.
is it page 15?
Page 150, Lordship.
150, I'm sorry.
The petitioners, they are also member of this Nagaland Medical Students Association. So they are associated, they have submitted representation.
Where is that thing to show that it has been postponed?
Page number 153. Yeah, different for 2 weeks. Now the period of 2 weeks is over. They are not taking out any steps either to recall or revoke the proposal.
Yes, madam, there seems to be something wrong.
Lordship, it's like this, Your Lordship. When the sick, we are facing the problem of COVID-19 pandemic. There was shortage of doctors and the medical staff everywhere.
Hmm.
Based on which the state government, we have created the post, Your Lordship. So during this point of time, when we created the post, the petitioner are still undergoing their studies. So after we created the post, we advertised through open recruitment. And these selected 98 doctors, they participated in the selection.
Madam,
Lordship.
madam, this code is disturbed because actually, while creating the post of doctors during the COVID-19 pandemic,
Yes.
you have not relaxed the rules. You have not relaxed the rules. Without relaxing the rules,
Your Lordship, so we have to see the situation.
no
When-
situation.
When we were in an unprecedented situation. Your
Yes,
Lordship,
that this
because
code
of the
understands.
COVID,
That
Your
this
Lordship,
code
that
understands.
also has to be taken into consideration.
That this code understands. but the-
Notwithstanding the service rule, Your Lordship.
That this, no, you cannot say notwithstanding the service rule.
Because
If there is to be any relaxation in the service rules before the appointment on exigency basis is concerned, you have to actually relax the service rule because without
Exactly.
relaxing the service rules,
Yes, that-
now how can this court go beyond the
Uh,
service rules?
For that matter, whether the department has relaxed, I think they must have relaxed the rule. But Your Lordship, we have to see that because of the unprecedented situation, Your Lordship. Had the petitioner, they participated in the exam during that point of time, and if they are still continuing, their name would have been in the present list, Your Lordship. Only those doctors who are still in service are in the list, Your Lordship.
But how can you appoint 98 doctors without any advertisement?
We have
without-
advertised the post, Your Lordship, we have advertised through open advertisement, Your Lordship. It's at page 116, Your Lordship.
Okay.
That was during
It's
the COVID time.
114, during the COVID time, we have advertised the post.
What is the nature of their appointment? Let us see.
The nature of the appointment, Your Lordship, it is to be for a period of 1 year and the recruitment to be conducted through MPSC. Yes, but Your Lordship, we have, because in order to acknowledge their selfless service during the COVID period, Your Lordship, we have given some weightage. So we have pushed the matter to the MPSC to conduct the exam. The MPSC declared that it was not within the norms of the rules to conduct such examination, and the MPSC has written that the department has to conduct through the departmental screening committee.
And that is not permissible.
It's not permissible.
That is not permissible as per the
Lordship,
rules.
we have to take into consideration the selfless, the risks they have performed during the COVID.
That is okay. We also understand. We also understand that. We also understand that. But when you have actually given appointed them without any relaxation in the service rules, at least before they were appointed, at least if the service.
Your Lordship, we have created the post. We have created 106.
See,
posts,
madam.
Your Lordship.
Madam, you have created 100 and so posts you have advertised.
Yes,
What is the nature of their appointment on contractual basis to be regularized by NPSC?
yes,
Simple as that.
yes. So Your Lordship, my saying is that had the petitioner were qualified during that point of time when the posts were advertised, and if they're still continuing in service, their name would be in the list.
See, the thing is that they have qualified.
Only
They,
now,
they have
only now.
qualified for the post
Mm.
when the service rule is still in existence. And therefore they are aggrieved. Because actually the appointment is sought to be made contrary to the service rules.
Lordship, this group of people who served during the COVID period has to be treated as a special class, Your Lordship.
But
So the petitioner, they cannot be classed.
how
this group, Your
do
Lordship.
we allow the government to actually appoint 98% in violation of the rules?
Lordship, as a one-time measurement,
No.
taking into consideration the services that are performed during the COVID. Because many of the doctors have resigned during those periods, the nurses also they have resigned. But they have took the risk of the life and continue and serve the public, Your Lordship. So in order to acknowledge what they have served, Your Lordship, as a one-time dispensation only, Your Lordship.
Madam, you may have a very good case in facts, but in law, maybe this court will not agree with you. Let us see your prayer, Mr. Lima.
My prayers to question the interim decision of the cabinet and to fill up the post as per the rules of the councils.
In the writ petition decided by this court, whether the prayer of the petitioner was for regularization in service.
Just the petition, serial number 119.
1 to 9. They were the petitioners in this writ petition. And they were seeking for regularization.
Your single regularization of the conviction.
Yes.
It was a
And
case either decision also, the department they have conducted the suitability test. He qualified in the suitability test. The report of the suitability test was forwarded to the cabinet. The cabinet approved the recommendation for regularization of the service. When the meter was thus situated, the employees of National Health Mission is teacher bodies, which compelled the executive cabinet again to recall their earlier decision. So they challenged in this repeat, in this WBC 70 of 2020, praying for declaration of the case in line with the two policy framed by the state government, 2006 and 2008, as well as para 53 of the Umadi case. However, this court refused to grant any relief letter to them. And now the department again a special consideration for them and club up them with the COVID-19. That is the action of that is the action which has been resolved by the department.
Mr. Limawabang, the learned counsel for the petitioner. Stop. By filing this writ petition, the petitioners are impugning the minutes of the cabinet meeting held on 6th August 2024, approving the regularization of service of COVID-19 appointees through departmental screening committee in relaxation of earlier approved procedures, and the letter dated 28/2024, written by the Principal Director, Directorate of Health and Family Welfare, Nagaland, Kohima, to all the chief medical officers, to the chief medical officers, to all the chief medical officers in the state, correct? In the state. The medical superintendent. No, to all the chief medical officers and the medical superintendent in the states, comma, the medical superintendent TB Hospital Mokokchung / TB Hospital Khuzema, comma, the medical superintendent State Mental Health Institute Kohima, comma, the principal paramedical training institute Kohima, and the senior medical officer CHC Tseminyu / CHC Procedural. For information of the doctors in the list to be recruited through special recruitment drive within bracket one-time dispensation. Stop. The list of doctors contains 98 names.
Medical officers.
The list of medical officers, the list of 98 medical officers is brought out in Annexure 1 to the letter dated 28/2024. It is the case of the petitioner that against the recruitment of the 98 medical doctors, they have submitted the representation dated
21. Should 21 each. No.
20,
21/8/2024.
21/8/2024. And pursuant to which the Principal Director, Directorate of Health and Family Welfare, as directed by the government, has deferred the special recruitment drive for 2 weeks. It is submitted that the special recruitment drive has not been held as of date. It is further the case of the petitioner that the proposal for appointment of medical doctors through special recruitment drive violates the Nagaland Health Service Rules 2006. Which provides that the junior grade, namely medical office, which provides that the appointment of junior grade, such as medical officers, junior specialist, junior dental surgeon, and equivalent post or post that may be declared or made from time to time by the government shall be filled up by direct recruitment, the minimum qualification for which shall be MBBS or equivalent degree of a recognized university. Mr. Lima Wabang, Learned Counsel for the petitioner submits that the appointment of the medical doctors, which is proposed to be initiated by special recruitment drive by the government, is clearly in violation of the Nagaland Health Service Rules 2006. And therefore, the action of the government to appoint the 98 medical officers by special recruitment drive cannot be legally sustained. Issue notice to the respondents, returnable in 4 weeks' time. MS V. Sokre, the Learned Government Advocate, accepts notice on behalf of the state respondent number 1
2, 3.
1 to 3. Therefore, no formal notice need be issued to the state respondents. Stop. The Learned Counsel for the petitioner shall however serve the requisite copies of the writ petition to the Learned Additional Advocate General
By tomorrow.
within a period of 2 days from today. Insofar as the respondent number 4 to
101.
101 is concerned, the Learned Counsel for the petitioner shall take steps for service of notice upon the said respondent by registered post with AD within a period of,
Within a period of 10 days.
within a period of,
Worship says I have to make all the Xerox.
yes, within a period of 10 days from today. In the interim, considering the submissions made by the learned counsel for the petitioner and also the facts and the circumstances of the case, the minutes of the cabinet meeting held on 6/8/2024 at additional agenda number 3, approving regularization of service of COVID-19 appointees through departmental promotion in relaxation of the approved procedure insofar
Yes,
as
medical officers.
insofar as the 98 medical officers are concerned, and
Page 146.
the letter dated 28/2024, written by the Joint Secretary to the Government of Nagaland, Health and Family Welfare Department, to the Principal Director, Directorate of Health and Family Welfare, Nagaland, Kohima. No.
Which is the next leader, 146.
What was that, ma'am?
Considering the submissions made by the local conflict and petitioners and also the facts and circumstances of the case, the minutes of the cabinet meeting held on 6/8/2024 at additional agenda 3, approving the regularization of service of COVID-19 for inclusive parliamentary promotion in relaxation of the
In relaxation of the approved procedure,
insofar written by the Joint Secretary to the Government.
written by joint from their council, written by the Principal Director, okay? Director of Health and Family Welfare, Nagaland, Kohima, to the Chief Medical Officer and the Medical Superintendent of the districts in the state, the Medical Superintendent, TB Hospital Mukokchung / TB Hospital Khuzama, the Medical Superintendent, State Mental Health Institute Kohima, the Principal Paramedical Training Institute Kohima, and the Senior Medical Officer CHC Taminu and CHC Procedural. Insofar as informing the medical doctors to submit the list for special recruitment drive. The names of the medical officers, which is enclosed as Annexure 1 to the letter dated 28, correct?
Yes, President.
28/2024 shall remain suspended till the next returnable date. Okay.
Can I declare the service rule at the time of the?
Oh, yes.
Yes, yes.
For motion item number 56.
May please, Lordship. My lord, the petitioner herein is aggrieved by the appointment order dated 14/10/2024, whereby the private respondent number 6 was appointed as medical attendant at Hangwe Sub-Center in the CMO Bokha. My lord, the short facts of the case is that on 31/3/2019, a vacant post of one medical attendant fell vacant. It's Hangpu's sub-center under CMO Wokha. And the petitioner, being eligible for the said post, has applied for the same. And the CMO of the district has forwarded the applicant of the petitioner along with another applicant to the principal director. And in the process, there was no advertisement or no interview was conducted. And again, in the year 2024, that is from May to August 2024, there were different applications were forwarded by the principal director to the commissioner and secretary. And the department.
Where is the impugn order?
My lord, it's at page number 23. The type copy is at page number 23. Page number 23, my lord. This is done without any advertisement or without conducting any interview, my lord.
Where is the approval letter? Any approval letter?
Yes, my lord. The approval letter is at page number 20, my lord. The type copy is page number 20, my lord. Till the filing of this writ petition, my lord, the respondent has not given his training report.
Mr. Swenson. Learned counsel for the petitioner. The petitioner being eligible had applied for the post of medical attendant at Hangwu Sub-Center under the establishment of Chief Medical Officer against existing vacancy. However, stop. The government of Nagaland in the Health and Family Welfare Department has, without issuing any advertisement and conducting any selection process, appointed, issued the letter dated 30/9/2024, conveying the approval of the respondent number six as medical attendant at Hangwu Sub-Center under CMO Wokha. And thereafter, the principal director, Directorate of Health and Family Welfare, Nagaland, Kohima, by the order dated 4/10/2024, has appointed the respondent number 6 as the medical attendant at Hangwu SC, Chief Medical Officer, Wokha. Issue notice to the respondents, returnable after 4 weeks. MSIME, the learned government advocate, accepts notice on behalf of the respondent number
1 to 5.
1 to 5. Therefore, no formal notice need be issued to the state respondents. The learned counsel for the petitioner shall, however, serve the requisite copies of the writ petition to the learned government advocate
Within 2 days, my lord.
within a period of 2 days from today. Insofar as respondent number 6 is concerned, the learned counsel for the petitioner shall take steps for service of notice upon the said respondent by registered post with AD within a period of
Within a week.
7 days from today. It is submitted by Mr. Takakichu. The learned counsel for the petitioner that the respondent number 7,
Six, my lord.
respondent number 6, consequent to the order dated 14/10/2024, issued by the Principal Director, Director of Health and Family Welfare, Nagaland, Kohima, has not joined the post as medical attendant at Hangbu SC, Chief Medical Officer, Oka. Stop. If that be so, comma, in the interim, the respondent number 5,
Six, my lord.
respondent number 5. That is the Chief Medical Officer, Oka, Nagaland, shall not allow the respondent number 6 to join the post in question, only provided, okay,
Yes, Your Lordship.
if he has not submitted the
Yes, Your
joining. Okay. Okay.
Bless, my.
For admission, item number 7.
May I please, Your Lordship?
Hmm.
Your Lordship, on behalf of K. Angami, kindly grant 3 weeks' time to obtain necessary instructions so as to file an additional affidavit.
What additional affidavit, ma'am?
Your Lordship, he did not give that
Your
instruction.
Lordship, on 10th of September, the petitioner's counsel has placed an office order letter with regard to spot verification.
Sport verification.
Yes, Your Lordship.
Huh.
And this honorable court has directed the state respondents to receive necessary clarification and instruction with
Which
regard to
is the
that.
order?
9th October 2023 was placed before this honorable court,
9
my lord.
October 20.
Yes, Your Lordship.
That is the order.
Yes,
October.
yes, Your Lordship,
9th
office
October.
letter. From the office of the customary court of Tobashis, my lord.
9th October.
Yes, it was placed on 10/9/2024.
Where is that order? 9th October.
Yes, Your Lordship.
Just wait, I'm just trying to press the 9th October 2024.
2023.
9th October 20, okay.
Yes,
9th
Your Lordship.
October. 9 October 20.
Yes. The order was passed on 10/9/2024.
10/9.
Yes, Your Lordship.
2024.
Yes, Your Lordship.
Right.
The order which was passed by this honorable court. And the office letter is 9/10/2022.
You don't
Lordship.
confuse 10.
Yes, Lordship.
Okay, so this letter 9/10/2023 was placed by you.
Yes, Your Lordship.
The learned government advocate. 6 for further,
3 weeks' time, Your Lordship.
what, 3 weeks, instructions, small instructions? Is it something to do with appointment of lane owners?
Yes, Your Lordship. I'm challenging the approval and appointment of respondent number 6.
the Learned Government Advocate is further granted 2 weeks' time to comply with the order dated 10/9/2024 to receive necessary clarification and instructions on the letter dated 9/10/2023, which is written by Head Dobashi Customary Court, Changtungia, to the Sub-Divisional Officer, Changtungia, Nagaland. Stop the clarification and instruction. I'm sorry, the government advocate shall place the necessary clarification and instruction positively on the next date fixed, okay? Listed after 2 weeks.
Obliged, my lord.
For admission, item number 8.
May it please your lordship, I'm
Yes.
appearing on behalf of my senior in-law, Kumar, your lordship.
Yes.
Please kindly list this matter after a week, your lordship, since my seniors need this spouse.
Your lordships.
Yes, but Mr. Moore-
Otherwise, I am ready with the instructions. On last occasion, that is 9/9/2000.
I am on that.
Yes, yes. So this three fellows,
Why were they left out?
they were also given your lordship. Why this three petitioner were left out was the question posed to me by this honorable court on last occasion. Lordship, may kindly see page 3.
This order,
Yes,
order 27/2024.
correct, your lordship. Yes.
What
This relates to petitioner number 3, your lordship.
petitioner number 3?
And the
No,
next page, next,
petitioner number 3 has been appointed.
yes, yes.
Okay.
That is the order, your lordship.
Okay.
Lordship may peruse the order. Very short.
Consequent upon the vacancy caused by the requisitioning of is hereby requisitioned as security guard and the establishment of the seat. So why Apung is the respondent number 3?
Yes, lordship.
Or petitioner or respondent? Respondent.
Petitioner, your lordship. Yes.
Ah.
And next page, your lordship,
Noplak.
page 4. Does the H Noplak Bong is petitioner number 4.
This is petitioner 3, petitioner 4.
And next page, your lordship, page 5 is petitioner number 5. Yel Daunyan Bong. So this 3 left out last occasion, they were also given so lordship the prayer of the petitioner in this petition has been complied with.
Has been answered.
Has been answered,
Why
complied.
don't you give a copy? We'll list it tomorrow again. Can you come tomorrow? I think the matter is already finished. Get instructions and come. Because as per this letter, you have already been appointed. So they'll show this letter to your seniors and then come with instructions tomorrow.
Your lordship, if it's on Friday.
Let him take her
Ah,
time, because if her senior is not available, then in that case. no
correct,
problem.
that's why.
I have no
Or,
problem.
like this case has not to do with any argument.
Yes, lordship,
The
if-
government, senior government advocate has only placed the order showing that you have already been appointed. So nothing remains. So why actually like just take instructions and come? We list it on Thursday.
okay, your lordship.
Okay, we
Yes.
list it on Thursday, Mr. Moore.
No problem. Obliged, lordship.
Yes, listed again on what is Thursday?
25th.
24th. Thursday is 24th, correct?
Yes, Lord.
Listed on 24/10/2024. Okay, if your senior is unable to come, you just receive a small instruction and come.
Okay, your lordship.
Okay?
Much obliged, your
Okay.
lordship.
Lordship, with due apology, I
Yeah.
was in the other court in the morning when the missioning was going on.
Haha.
I'd like to mention item 49 and 50. I have a meeting at 1:30. I was called for a meeting in secretariat at 1:30 today.
Okay.
So if my friend
Well,
agrees, let this matter become of tomorrow.
thank
This matter relates to your lordship, grant of scale up pay to contingency and casual employee. Two petitions are club up and it has to be heard. Otherwise, I'm ready for hearing.
There is already an order passed by the Honorable Supreme Court.
Lordship,
But
The status appeal against the order passed by this court. Division bench, of course.
I'm aware of that, your lordship,
But
but then,
of course, the facts.
yeah. Let this matter become of tomorrow if my friend agrees.
no objection, your lordship.
Yeah, who is leading you in this case?
Myself, your lordship.
Yourself.
Actually,
Very good, very good.
I need tomorrow.
Yes, Mr. Muzai.
In fact, this is purely to do with the state lordship. I'm for the AG.
The scale of pay.
Yes, if the government give, then we'll definitely process after the state.
You always say that before the court, and whenever actually documents are submitted in your office, you request no rejection.
That depends on the government, how they take a decision to that effect.
We listed it.
Lordship, I have some points to be bring out before
Okay,
you.
okay, very good.
Tomorrow.
Listed again, pass over the matter, pass over totally. We pass over. Let's see tomorrow.
Obliged.
Obliged.
For admission, item number 9.
Your lordship, here I'm yet to receive the parawise comments, so kindly grant me 3 weeks time.
Who is for the petitioner? Justin Monk. None appears for the petitioner on call. Stop MS AIME, the learned government advocate, is allowed 3 weeks' time to receive instructions and to file the affidavit in opposition.
Much obliged, your lordship.
For admission, item number 10.
Yes, Mr. LT.
Yes, may it please your lordship.
Yes.
This is regarding the construction of Tunne in Parent District.
Yes.
I've received instructions, however, it is not satisfactory. I will be seeking more instructions from the state
The
respondent.
last
So
time you said you have received instructions
Yes.
that you may be granted some time to file affidavit in.
I
opposition.
saw some more instructions, further instructions, but I'm yet to receive the
Mr.
further.
Tanti, have you filed your,
Yes, I filed on 16th of February this year, lordship.
you have for 1 to 3
Yes, my lord.
and Mr. LT is for respondent number?
Four
State-
4 to 8, my.
4 to 8.
Yes.
Mr. LT Sanctum, the learned additional advocate general for the state respondent number 4 to 8. Submits that he has received the instructions. However, further clarification
Yes.
has been sought from the government and therefore requires 3 weeks' time to file
Yes,
affidavit in opposition. Prayer is allowed, listed in bold.
Lordship, if my presence may kindly be reflected.
Yes, Mr. Sentianger, the learned counsel for the respondent number 1, 2, and 3. Appears.
Much obliged, lordship.
Sentianger appears for the respondent number 1.
For admission, item numbers 11 and 12.
May I please, Lordship? Lordship, kindly grant me 3 weeks' time to file my reply, Lordship, to the affidavit filed by respondents, Lordship.
Who are the parties?
Nagaland Handloom Handicrafts Development Corporation Limited. The respondents, I've received the affidavit filed by them. I need to file a reply, Lordship.
You are appearing for Handloom?
Yes, 1 and 2.
As the engaged counsel.
Lordship.
What about 3?
Lordship, I've taken steps. And we have taken justice service also, and we have filed I filed my affidavit in that respect, but they have not appeared, Lordship.
And what has respondent number 3 got to do in this case?
Lordship,
Yeah.
this is a seniority case, Lordship.
Oh,
Seniority. So they have superseded me.
So let us see the orders. They have filed affidavit, stating service of notice.
Lordship.
Where is it? Which affidavit? 6 June.
Lordship, yes, Lordship. Affidavit was filed on 11 of
Learned the additional AG has filed affidavit. You have filed the affidavit on behalf of R1 and 2.
Yes, we have already filed.
Where is your affidavit stating service?
Lordship. Affidavit was filed on 11th of March, Lordship, 2024. March, Lordship.
Where is that order?
Lordship, order is 10/5/2024, Lordship.
12/2/2024. That's this honorable court by order dated 12/2/2024, as per your affidavit.
Petitioner to fresh steps by the service.
12/2/2024. What was that order, Mr. Prosecco? 12
12/2/2024, the petitioners are directed to take fresh steps by way of that service upon respondent 3.
That is 12, I'm sorry.
12/2/2024, Lordship.
12.
And on the 10th,
Yes, wait. But there is no order 12/2.
12/2/2024, Lordship.
There's some analogous matters. There's some analogous matters.
Lordship, analogous matters.
Tagged with this,
Yes,
tagged with this present case.
Lordship. There are two
Yeah,
petitions, Lordship.
Where is that order directing you to take steps? The London Council for the place for and is granted 2 weeks' time to file affidavit of service of notice on respondent number 3 by Dusty.
Accordingly, I have taken steps and I've filed the affidavit.
Fresh steps.
And on by order dated 10/5/2024, Lordship may come to order dated 10/5/2024. 10/5/2024, service upon respondent 3 in
It's deemed served.
It's deemed served, Lordship. Deemed served.
Number 3.
Yeah,
Okay.
deemed served.
Okay,
And accordingly,
so it is deemed served.
deemed served, Lordship. Deemed served.
So you want some time for?
Some time to
affidavit
reply. Reply to the affidavit filed by the
Respondent 1.
respondent to Lordship.
So Prosecco, okay. The London Council for the petitioner is allowed
3 weeks, Lordship.
3 weeks' time. You file affidavit in reply to the affidavit in opposition filed by the respondent number 1 and 2. Okay.
Lordship. Are you obliged, Madam?
For admission, item number 13.
Your Lordship, by order dated 27/8, I was directed to get the necessary instructions with regard to the petitioner's status. His case is with regard to regularization. At the time of filing the affidavit, I have stated that his case is under consideration, but I have received further instructions that his case, the PNR has given its clearance with regard to the petitioner's case, and now is under process to be sent to the finance department, Your Lordship.
Where's that instruction? That was. You give him a copy also. You give him a copy. What is your case for regularization?
Lordship, it's regularization post-retirement work charge. Regularization of service post-retirement for pension benefit only.
It's a posthumous regularization.
Post-retirement, not posthumous.
Posthumous,
Posthumous, post-retirement,
post-retirement,
post-retirement.
Okay. MS. Yeah, IME. The Learned Government Advocate has placed a copy of the letter dated 11/9/2024, written by the Additional Secretary to the Government of Nagaland, Works and Housing Department, to the Engineer-in-Chief and PWD, Nagaland, Kohima. Wherein it has been conveyed that the petitioner's case for service regularization is the petitioners for service regularization has been cleared by the PNR department, and the matter is under process to be sent to the finance department for clearance. Stop. In terms of the letter dated 11/9/2024, MSIME seeks for further 3 weeks' time to receive necessary instructions. Prayer is allowed, listed accordingly.
Much, Lordship.
For admission, item number 14.
May I please, Lordship, kindly grant me 3 weeks' time to file my reply, Lordship, to the filed by the respondents. State respondents, Lordship.
Mr. Pusako Hotel, Learned Counsel for the petitioner, is granted 3 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Where is allowed, listed accordingly. The interim order passed earlier
Lordship,
shall
kindly,
continue till the next return.
Bless me.
We'll resume at 2.
Not granting the permit. My probably have a
We are hearing some. I have a similar case. I can same as yours. I can like, only to. Oh. Okay, thank you.
For admission, item number 15.
My pleasure, Lordship.
Yeah.
Lordship, a week time may be granted Your Lordship to file reply, Your Lordship.
Mr. Subhamurthy Wali, the learned counsel for the petitioner is granted 1 week's time to file affidavit in.
Obliged, Lordship.
For admission, item number 16.
Your Lordship, here state is yet to file affidavit, so kindly grant me 3 weeks time.
MS AIM, the learned government advocate is allowed 3 weeks time to file affidavit.
Much obliged.
For admission, item number 17.
May I please, Your Lordship? Lordship, here I'm yet to file reply. I have taken the concern of the opposite party, the government advocate. Kindly allow me 3 weeks' time.
Mr.
Ali Bauzukum, Lordship.
Aliba Uzakam, the learned counsel for the petitioner is allowed 3 weeks time to file reply affidavit to the affidavit in opposition filed by the government. That's the recording.
Obliged, Lordship.
Item number 18.
Please, Your Lordship. Please, Your Lordship. Yes, yes, Chair.
Your Lordship, state has already filed the affidavit. Petitioners were to file the reply.
Your phone, your phone.
I'm for the private respondent 4.
You file your affidavit.
Yes, Lordship.
May I please, Your Lordship?
Yes. Yes, please. Yes. You are not audible. This is the problem.
Lordship, kindly grant me 3 weeks time to file.
See, he is Mr. C.D. Rungsan.
Lordship.
Huh? Mr. C.D. Rungsan is allowed 3 weeks time to file affidavit in opposition. To file a reply affidavit to the affidavit in opposition filed by the state respondents as well as by the private respondents. Okay.
Much obliged.
Much obliged, Lordship.
Item number 19.
May I please, my lord?
Yes.
Lordship, in this matter, I'm here to file my counter affidavit. I have received the necessary paragraphs comment recently. If 3 weeks' time can kindly be granted, my lord.
Mr. Nangami, the senior government advocate submits that he has received the instructions and would require 3 weeks' time to file the affidavit in opposition. Prayer is allowed, listed accordingly.
Your
The
lordship, there's an
interim order
interim.
passed earlier shall continue till the next.
Deeply obliged. my lord.
Item number 20.
Your lordship, on behalf of Inaoli, kindly grant 3 weeks' time to file affidavit.
Yes,
My lord, this may be the last.
she has received the instructions.
Yes, your lordship, she's here to file the affidavit, so.
MS. Inauli, the learned government advocate. Is granted the last chance to file affidavit in opposition. Listed after 2 weeks.
Much obliged.
Item number 21.
Yes,
Please, your lordship.
yes.
In this, I'm for respondent number 2 and 3. Lordship, I'm, kindly allow me 2 weeks' time to file my affidavit in opposition, your lordship.
One, Mr. Nangami,
Yes, your lordship.
will it not be necessary to file? Or you have filed?
Lordship, in this matter, in fact, it is Ki Angami who is actually handling the matter. But Lordship, we have been informed that Steve is just a pro forma respondent here.
Yes, your lordship.
MS Naksing Tila. The learned counsel for the respondent number 2 and 3. He is granted 3 weeks' time to file affidavit of reply,
In opposition, your lordship.
affidavit in opposition. Okay.
Much obliged.
For admission, item number 22.
May I please, your lordship?
Hmm.
Lordship, I am appearing for respondent number 2. And on behalf of Suman Chitia, the standing counsel for Income Tax Department. Lordship, we have filed our vakalatnama today. Lordship, may kindly grant us 4 weeks' time for filing on affidavit in opposition.
Who is for 1?
Your lordship, I'm appearing on behalf of my senior for respondent number 1. We're also yet to get instructions, so sometime may be given us.
MS. So and so. Appearing on behalf of Mr. Yamarwati, learned CGC. As well as Mr. Your good name. So and so. Appearing on behalf of Mr. So and so. Learned counsel for the respondent number 2. Are both allowed 3 weeks' time to file their respective affidavit in opposition.
Much obliged.
Lordship, there's an interim.
The interim order passed earlier shall continue till the next.
Item number 23.
May it please your lordship.
Yes.
This is about Ministry of Consumer Affairs White Memorandum dated 9/6/2016. Issued direct selling guidelines. So the petitioner before this honorable court is praying for a direction to issue guidelines, notification and circular from the.
Have you filed your affidavit?
No, my lord, I'm yet to receive the detailed instructions.
What about you, ma'am?
Your lordship, we have filed.
So may I pray that 3 weeks' time may be granted.
Mr. LT something. Learned additional advocate general. for the state respondent. 1 to 4
Yes, my lord, 1 to 4.
is allowed 3 weeks time to file affidavit.
For admission, item number 24.
Where's the authorities?
We are on 101. IA 101.
Yes, your lord. Yes.
Yes, my lord, yes.
What is that IA?
It's for the vacation of the interim order, my lord. Your lordship, on the last occasion, if your lordship will remember, a submission was made that whether Article 226(3) is directory or mandatory, that has been referred to the full bench.
Full bench of the High Court?
Yes, my lord. Now, the full bench has answered the reference. And that is in 2024, 4 GLT, page 779.
That's it.
Page 779. So, has the lordship got it? Page 779? Now, your lordship will see at page 780, in the list of authorities which have been referred to, at serial number 26, at the top of the page. Serial number 26. Yes. Serial number 26. And this is
2024-6.
6 SSC 267. Now, this is a decision of the Constitution Bench of the Honorable Supreme Court. And the Constitution Bench also has actually decided this matter. But in the full bench, your lordship, only one particular paragraph of the decision of the Constitution Bench has been referred to. May I take your
Now,
lordship?
Mr. Jimomi,
Yes, my lord.
before we go to this citation, let me first know the facts. Let me first know the facts. Let us see the dates, because I think the dates will be important
Yes.
for deciding this issue.
Uh,
26.
Your lordship,
Let us.
on the last occasion, your lordship had already noted the dates. We can, of course, I'll go back again.
Okay.
So I was under the impression that
Nothing is
it was
there.
not necessary.
Yes, the dates.
Yes, your lordship. So the IA was filed on 5/7/2024. Five, 7/2024. 5th of July, 2024.
No, as per the registry's filing assistant,
Yes, ma'am.
it is 8 July 2024.
We serve copies on the 5th of July. 5th of July.
So
Your
from
lordship,
which date it has to be taken, whether it is
if
from
we, if we
8
can
or-
go to the 226(3), your lordship. Constitution of India, 226(3).
Yes, let us read this. 226(3).
226(3).
Yes.
Your lordship, I'm just getting a copy of the Constitution. Give
Oh,
one
yes,
minute,
yes,
my
yes,
lord.
it's all right, it's all right.
May I read, my lord?
Yes.
Where any party against whom an interim order, whether by way of injunction or stay or in any other manner, is made on or in any proceedings relating to a petition under clause 1, without A, furnishing to such party copies of such petition and all documents in support of the plea for such interim order, and B, giving such party an opportunity of being heard, makes an application to the High Court for the vacation of such order and furnishes a copy of such application to the party, in whose favor such order has been made, or the counsel of such party, the High Court shall dispose of the application within the period of 2 weeks from the date on which it is received, or from the date on which the copy of such application is so furnished.
Yes.
Whichever is late.
Let us, on which it is received.
Or from the
2 weeks from the date on which it is received, or from the date on which the copy of such application is so furnished.
Yes, my lord.
Can you kindly explain that?
So, my lord, yes, my lord. So the High Court shall dispose of the application within a period of 2 weeks from the date on which it is received, or is received in the High Court. No, it is received by the opposite side, my lord.
On which it is received.
Yes, my lord.
On which-
Or from the date on which the copy of application is so furnished. More or less the same thing, my lord.
On which it is received.
Whichever is later. Whichever is later. So I actually served the copy on the 5th. Your lordship will see that on the inner side of the application, your lordship, the date of receipt. The opposite side has received the copy on the 5th.
It says by the state respondents.
Even by the private respondent, your lordship, on the 5th.
Which?
In the first page of the cross title page, your lordship. So 150.
No, it only says we undertake to send the copies to the opposite parties at the earliest.
So when did you send it? It was the other day you gave me the date, isn't it? Let's see, when did you send?
Mr. Ejmon.
My lord, it
Can you
was,
see the order dated 9/7/2024?
yes, my lord, it was moved on the 9th.
It was moved on the 9th.
Yes, my lord.
So by then, no copies had been served.
By then copies had already been served.
The learned counsel for the application shall however serve the requisite copies of the application to the learned counsel for the respondent in the course of the day.
Yes, my lord.
So that means earliest it was served by on 9/7/2024.
Okay, we can take that date also, my lord.
9/7.
Yes, we can take that date also.
So we
Right.
take this.
Yes, my lord, 9/7. We can take that date.
So this was the petition was listed for motion.
Yes, my lord. So 9/7. So if we are to take 9/7 as a date.
Yes, madam. Are you in agreement with that? 9/7 because the order clearly reflects.
Yes, your lordship.
Okay.
So then the matter should have been heard by 23rd.
Just wait. So counting from 9/7
Yes, my lord.
as per 226(3).
Yes, my lord. 14
2 weeks
days.
will expire on
23rd, my lord. Should have been heard by the 23rd.
application for vacation.
Yes, my lord. Should have been heard by the 23rd.
23/7/2024.
Yes, my lord.
Okay, let's see the orders of this school. Mr. Timomi,
Yes, my lord.
thereafter, after 9/7/2024, the matter was next listed only on 5/8/2024 by this court.
Yes, my lord. So, your lordship,
So it is the fault of the court.
your lordship, that could be one way of looking at it. But it was incumbent upon the writ petitioner to ensure that the matter was listed and the application heard and disposed of. And your lordship, as far as 226(3) is concerned, it brooks of no exceptions, your lordship. No exceptions. There are no exceptions. And the Honorable Supreme Court has held that it is not directory, it is mandatory. And this Honorable Court in a full bench has also answered a reference, your lordship. It is not directory, it is mandatory.
So what you mean to submit is that despite the court fixing the date on 5/8/2024.
Yes, my lord.
It should have been heard on or before
23rd.
23rd.
Yes, my lord.
23/7/2024.
Yes, my lord. Yes, my lord. Any other interpretation, your lordship, would mean negating 226(3). Any other interpretation would mean negating 226(3). And 226(3), a constitutional provision, cannot be negated, your lordship. So this issue, the point which your lordship raised about whether 226(3) can be held to be directory and not mandatory, that has been answered, your lordship. Concerns like what your lordship has just expressed, your lordship. Those were the reasons why the reference was made to a full bench. And in the citation which I have placed before your lordship, just now.
Yes. Yes, observation has been made on 5/8/2024. Mr. A. Jimomi, Learned Counsel has submitted that as on date, Article 226(3) is in operation, and therefore the grant of time to the petitioner opposite party may not serve any effective purpose.
Yes, madam.
Thereafter, on 13/8/2024, the issue as to whether the interim order dated 22/4/2024 passed by this court in WPC 58/2024 stands vacated in view of operation of Article 226(3) is kept open.
Yes, my lord, it was kept open. And I must place these decisions before your lordship,
Yes.
otherwise.
No,
the-
Mr. Jimomi,
Yes, my lord.
before coming to the decision, I just want to know the facts, exactly the facts
My lord.
on the dates, I mean, not on the merit, on the dates. On the dates of the keys, the dates fixed by this court.
Yes, my lord.
So that your this petition under this 226(3) can be appreciated more better.
My lord.
So
My lord, my application was moved on the 9th. 9th.
on the 8th, it was listed for motion on the 9th,
Yes, my lord.
correct?
Yes, my lord.
8th,
Yes.
just let me note of this.
It was listed on the 9th, my lord.
Yes, application,
Was
it was in fact filed on 8th.
a file on 8th and moved on the 9th. In fact, your lordship, it was.
Yes, Mr.
Yes, my lord.
And on that date, if you take 9th as a date on which I furnished a copy, Your Lordship, the date starts,
That is admitted.
time starts running from that date.
Okay.
Now, therefore, after the filing of the application, the matter should have been heard by the 23rd. That was not done. The respondent also filed their objection only a copy which we received.
Now, Mr. Jimomi,
My lord.
just to clarify a doubt, if actually this court had not fixed the date on or before 23rd, but on 5/8/2024,
My lord.
what would be the?
No, my lord, there was another order. When the matter was moved, a date was fixed. What was it?
It was moved on 9.
Yes, my lord. And
it was only made returnable after 2 weeks.
yes, my lord. So that is within 2 weeks. And within that time, the party was allowed to file an objection, if any.
After 2 weeks. Returnable after 2 weeks.
Nevertheless, my lord, if it is made returnable after 2 weeks also, nevertheless, my lord. Nevertheless. The point is, Your Lordship, by whatever means, the mandate of Article 226(3) cannot be negated
Yes.
by whatever means.
I'm just recording this to satisfy myself.
Yes, my lord.
So, made returnable after 2 weeks.
In fact, when the matter was first argued, Your Lordship, my learned friend wanted 3 weeks' time. I corrected her. And then I said, if you ask for 3 weeks' time, 226(3) will operate. To be fair on the other side, to the other side. It's okay. No. No, I understand. It's there in the order. Then makes 10 days time. I should do.
Let us see the judgment. Let us.
Yes, my lord. So
Which judgment you want to refer?
First is-
Full bench.
the full bench first, Your Lordship. The full bench. This is 2024 4 GLT, full bench at page 779. This is the answer to the reference, Your Lordship. A full bench of 3 judges. Has the Lordship got it?
Yes.
If you can go straight to paragraph 29 at page 791.
Let us see the facts also. Let us see the
The,
facts.
the question is at,
Yeah.
at
The
paragraph
reference.
2. At paragraph 2.
Reference.
The reference is the question is at paragraph 2. The points of reference. The division bench of this court, by the judgment and order dated 26/6/20, in writ appeal 3K20, deemed it appropriate that the issue as to whether sub-article 3 of Article 226 of the Constitution is directory or mandatory be referred to a larger bench, taking into account that the said learned division bench had opined that Article 226(3) of the Constitution of India is directory in nature, whereas the coordinate benches of similar strength of our High Court in the cases of such and such of the had decided that Article 226(3) of the Constitution of India is mandatory in nature. But this was the reference, Your Lordship. This was the reference. Can we go to the,
Yes, we did.
okay. Can we go to the reference, the answer now, Your Lordship, to the reference? We start from paragraph 29. At page 791. Has Your Lordship got it? After discussing various authorities, Your Lordship, defining the answer is at paragraph 29. We accordingly hold that Article 226(3) of the Constitution is not directory in nature, which means it is mandatory. It is mandatory. And then further discussions, Your Lordship, and then if Your Lordship will come to page 38, paragraph 38, at page 794. At page 794. Para 38. Now, Your Lordship, this is with reference to the decision of the Constitution Bench of the Honorable Supreme Court, at which was at serial number 26 in the list of cases referred to, Your Lordship. That is 2026 5 SSC 1, 2024 6 SSC 267, serial number 26 in the list of authorities. So the full bench, Your Lordship, has referred to this case, but only in a different context, in the context of what is the interim order. And Your Lordship will see that in the middle of the page. In the middle of the page, before the quotation, Your Lordship, in small letters, showing paragraph number 16, page 794. Page 794.
Para 38.
Para 38. And if you move to the middle of the paragraph, Your Lordship, on the other side, where the paragraph 16 is quoted. Has Your Lordship got that? Paragraph 16 of the citation is quoted. Has Your Lordship got that? And before the...
Why don't we read the 38 from the beginning?
Your Lordship, not so relevant, that is why. Not so relevant. This is with reference to the Constitution Bench of the decision of the Constitution Bench of the Supreme Court. Your Lordship, we find it, we can start from the sentence just above the quote. We find it relevant to
reproduce.
To reproduce the observations of the Supreme Court in paragraph number 16 of the judgment in the case of High Court Bar Association of Allahabad Supra. When a High Court grants a stay of the proceedings while issuing notice without giving an opportunity of being heard to the contesting parties, it is not an interim order, but it is an ad interim order of stay. It can be converted into an interim order of stay only after an opportunity of being heard is granted on the prayer for interim relief to all the parties to the proceedings. Ad interim orders, by their very nature, should be of limited duration. Therefore, such orders do not pose any problem. So this is with reference to the Constitution Bench judgment. But actually, Your Lordship, in making these observations, the Supreme Court goes on. Supreme Court goes on in this decision and actually decides on whether Article 226(3) is directory or mandatory. That part I will bring to Your Lordship's attention again in the other judgment. Now, in this judgment, Your Lordship, at paragraph 45, further answer to the reference.
Full bench.
Yes, my Lord. Paragraph 45 at page 797. Paragraph 45. May I read, my Lord?
Yes.
Accordingly, we decide the reference as herein under. 1. Article 226(3) of the Constitution is not a directory provision, meaning thereby it is a mandatory provision. An order referred to in Article 226(3) of the Constitution is an ad interim order. The said ad interim order is required to be of limited duration, or in other words, the existence of the ad interim order has to limited to a date so fixed. The ad interim order is converted to an interim order only after an opportunity of being heard is granted on the prayer for interim relief to all parties to the proceedings. 4. The High Court on an application filed under 226(3) of the Constitution may reject the application or vacate, modify and or alter the ad interim order, or may extend the ad interim order in the presence of the parties to the list. Once the ad interim order is extended after hearing both the parties, it shall then be converted into an interim order, and the prescription for automatic vacation of the ad interim order for not being disposed of within 2 weeks cannot be applied. However, the High Court can still vacate the interim order on various grounds. 1. When a litigant, after obtaining an interim order, deliberately prolongs the proceedings either by seeking adjournments on unwarranted grounds or remains absent when the main case in which the interim relief is granted is called out for hearing before the High Court, with the object of taking undue advantage of the interim order, and or when the High Court finds that the interim order is granted as a result of either suppression or misrepresentation of material facts by the party in whose favor the interim order of stay was made, and or 3, the High Court finds that there are material changes in the circumstances requiring interference with the interim order passed earlier. The above grounds so stated are not exhaustive, and there can be other valid grounds for vacating an interim order. The term makes an application to the High Court, and the date on which it is received would mean when the application is filed seeking vacation of an ad interim order is placed before the learned judges who is holding the roster as endorsed by the learned Chief Justice of the High Court, and the date on which such application is listed before the learned judge for the first time. So that is, we are on the same date, Your Lordship, on the 9th of July. Before parting with the records, we feel not necessary, Your Lordship. So this is the answer to the reference. 226(3).
Just wait for, once the ad interim order is extended, once the interim order is extended, after hearing with the parties.
Yes.
It shall be converted into an interim order, and the prescription for automatic vacation of the ad interim order for not being disposed within 2 weeks cannot be applied.
Yes. So my application is yet to be disposed of. It hasn't been heard, Your Lordship.
Once the ad interim order is extended, once the ad interim, that means once the ad interim is extended after hearing the parties.
After hearing parties. Not in the absence of the parties, Your Lordship.
And the prescription for automatic vacation of the ad interim order for not being disposed within 2 weeks cannot be applied. So what you mean to submit is that after referring to this judgment, what you mean to say is that actually, if the ad interim order is not disposed within the period of 2 weeks.
Yes, my lord.
It lapses.
Yes, my lord. Automatically stands vacated. If the application I have filed for vacation of the ad interim order is not heard within 2 weeks, it automatically lapses. That is the mandate of 226(3), Your Lordship. Can I take Your Lordship to the Supreme Court's decision?
Yes, please, yes, please.
Lordship, it was not at interim. Lordship, the parties were heard, but only through implement the other.
Yes, I was not heard.
The respondents were made as a party, Lordship. It was not at interim.
No, no, no. In
Yes,
the
Your
first instance, maybe it was not ad interim. But after the High Court had filed the application, it ought to have been heard within 2 weeks.
Lordship, if I may, a small clarification regarding the receiving of this and hearing of the
No, let me,
application, Your Lordship.
I'll come to you. Let me first. Yes,
Your Lordship, we were not made a party initially. We were not made a party.
We were just challenging the order of
Yes.
the Deputy Commissioner.
The High Court
Lordship,
impeded itself.
by illegally cancelling the party.
And after we impeded ourselves, we filed this application for.
We are not agreed with the allotment order, Your Lordship.
So the interim order was passed in our absence. No dispute about that, Your Lordship.
okay, let us see.
Now, Your Lordship, this is the Supreme Court case, Your Lordship. The 2024, this volume is not available.
Which one?
The one which I was referring to in the full bench judgment, Your Lordship, 2024, 6 SCC 267. We don't have that yet, Your Lordship. The copy hasn't come to us, but I have downloaded from the Supreme Court website the judgment, Your Lordship.
This is the judgment.
This is the judgment. Yes.
This will let me also review. This is 2024 6 SSC 267.
Yes, my lord. Yes, madam. This is the Supreme Court website, Your Lordship, and the paragraph 38, which I was referring to earlier, Your Lordship, in the Supreme Court website, the paragraph number is actually 14. If Your Lordship can come to page paragraph 14, internal page 16. Page 16. Has Your Lordship got that? Paragraph 14. When a High Court's power to vacate or modify interim relief. So this is the paragraph 16, which is
Paragraph 14.
yes, madam. This is the paragraph 16, which is reproduced in the paragraph 38 of the full bench judgment.
Yes, wait, let me do. This is para
Para
16.
16 in paragraph 38 of the full bench judgment. And the answer, as far as Article 226(3) is concerned, Your Lordship will find in paragraph 26.
Yes, paragraph 14.
Paragraph 14, Your Lordship, is actually what has been quoted in paragraph 38 of the full bench judgment.
Let us just see this paragraph 14.
When a High Court grants the stay of the proceedings while issuing notice without giving an opportunity of being heard to the contesting parties, it is not an interim order, but it is an ad interim order of stay. It can be converted into an interim order of stay only after an opportunity of being heard is granted on the prayer for interim relief to all the parties to the proceedings. Ad interim orders by their very nature should be of limited duration. Therefore, such orders do not pose any problem. This is what is quoted in the full bench judgment, Your Lordship, at paragraph 38. But the numbering is as paragraph number 16.
Yes.
And paragraph 26 now, Your Lordship. This is with specific regard to 226(3). 26.
Para 26.
Yes, my lord.
26, yes.
26. Clause 3 of Article 226 of the Constitution.
Yes.
In this case, it is unnecessary for this court to decide whether Clause 3 of Article 226 of the Constitution of India is mandatory or directory. Clause 3 of Article 226 reads thus. Then this is a reproduction of Article 226(3). And the next page, Your Lordship. Next page. On its plain reading, Clause 3 is applicable only when an interim relief is granted without furnishing a copy of the writ petition along with supporting documents to the opposite party and without hearing the opposite party. Even assuming that Clause 3 is not directory. So the Supreme Court actually answers and says that Clause 3 is mandatory. Clause 3 is assuming that Clause 3 is not directory. It provides for an automatic vacation of an interim relief only if the aggrieved party makes an application for vacating the interim relief and when the application for vacating the stay is not heard within the time specified. Very clear, Your Lordship. The answer is Supreme Court has already answered 226(3). It is mandatory, and if it is not heard within the specified time, it stands vacated automatically. Clause 3 will not apply when an interim order in a writ petition under 226 is passed after the service of a copy of the writ petition on all concerned parties and after giving them an opportunity of being heard. It applies only to ex parte ad interim orders. So it was an ex parte interim order as far as I'm concerned, Your Lordship. 101 application. Petition. Maybe we bleed ourselves by already.
No, Mr. Imami, there's a slight confusion because actually the interim order was passed by hearing the parties, the initial parties.
Yes, my lord.
And thereafter, you had actually submitted an application for
Impletement.
yourself.
Yes, my lord.
Yeah. Now, whether the order earlier passed should be treated as an ex-party interim order insofar as you are concerned.
Yes, my lord. It must be your lordship. I am not in the picture until the time I implead myself, your lordship. If I implead myself, it does not mean that I become a party from the date when the interim order is passed, your lordship. That means once an interim order is passed, lordship will look at it on the flip side. Once an interim order is passed, it applies to any party who may join in the proceedings. That would be a proposition which would negate 226(3), my lord.
Kindly read the fourth line again. Let us.
Which one, your lordship?
The fourth line of page, starting page 34. On its plain reading.
On its plain reading.
Yes, yes, one,
Yes, madam.
2, 3, 4.
Okay. On its plain reading, clause 3 is applicable only when.
No, even, oh, so much disturbance.
I think you can instruct your port officer.
You read from this, even assuming.
Even assuming that clause 3 is not directory, which means it is mandatory. It provides for an automatic vacation of interim relief only if the aggrieved party makes an application for vacating the interim relief and when the application for vacating stay is not heard within the time specified. Only if the aggrieved party.
So this will be applicable to you. Even assuming that clause 3 is not mandatory, it provides for an automatic vacation of interim relief.
Yes, ma'am.
Only if the aggrieved party makes an application for vacating the interim relief.
Yes, ma'am.
You have made
I have made the application, your
and
lordship.
when the application for vacating stay is not heard within the time specified.
Yes.
Okay. Okay.
So that is my application, your lordship. So there are two IAs in both the writ petitions. I'm asking for the same prayer, your lordship. Vacation of the interim order.
How much disturbance?
Now that the lordship, there was one more point which I wish to bring to your lordship's notice. If your lordship will recall, on the other day when the matter was being heard, and your lordship was of the put a query to me as to whether once a reference is made, the law declared
Please call the court officer.
not done. So this would mean actually, Your Lordship, when the full bench reference was being answered, the answer was already there by the Honorable Supreme Court in the Constitution bench.
Please tell them to stop that for the time being. Tell them to start at 4:30 only.
Not during court working hours.
No. We are getting so much of disturbance. Okay? Please tell them to stop it immediately.
So there was a common judgment by 4 of the honorable
Let
judges.
us see the judgment, the order passed by this court. The interim.
The interim order, Your Lordship, that is order dated 22/4/24. At my application 101, Your Lordship, at page 19.
So.
May I read, my lord?
Yes.
Heard the learned counsel appearing for the petitioner, also heard learned government advocate, state of Nagaland, representing the state respondents. The learned government advocate prays for some time to take instructions. Prayers allowed. I have also heard the learned counsel of both sides in the matter of prayer for interim order. Both sides are directed to maintain status quo as on today in respect to the disputed land. So, in fact, Your Lordship, it has not been an ad interim order. It was just an interim order. It was not even till the, it was not of limited duration in terms of the prescriptions of 226(3), or in terms of the decision of the Honorable Supreme Court, Your Lordship.
Both sides are directed to maintain status quo as on today in respect of the
Disputed land.
Sir, hey, Mommy,
Yes, my lord.
one doubt is that if this interim order is vacated,
My lord.
it will mean allowing the High Court to take construction of the wall.
Yes, my lord.
Yes.
As far as the,
So when the dispute is still pending,
and in fact, Your Lordship, that dispute is pending before the commissioner, where the petitioner is already appearing.
still not decided by the commissioner.
According to the documents placed by the opposite side, the commissioner is now waiting for his honorable court to decide first. It should be the other way around. The commissioner should decide, and if the petitioner is aggrieved, it is open to them for them to come to this honorable court again.
Where is the order passed by the commissioner? Let us see.
There was an additional affidavit which was filed. It was filed on 11/7.
Yes, madam, you have filed
Yes, Your Lordship.
When was this filed? No. Till days. I could. Till official information.
where is it in post?
So this is fine. No? This is when it's-
Your additional,
Yes, Your Lordship.
which we received on 7th of August, Your Lordship. 7th of August,
in the main,
Yes,
main
madam.
writ petition.
in the main writ petition, in the main writ petition. There's a document annexed as Annexure O at page 10. Additional affidavit which we received on 7/8/2024.
Lordship, if I may, Lordship. One submission. Before filing of this writ petition, Your Lordship, there was already a status quo order that was passed by the Commissioner, Your Lordship. Lordship, with regard to the construction.
That first status quo order was vacated. Was vacated by the deputy commissioner.
No, Your Lordship,
No.
it's still there, still continuing. And regarding the construction, Your Lordship,
So.
they've already completed, Your Lordship, they have already
If,
completed.
if, the deputy commissioner has passed the status quo order,
Your Lordship.
what harm will it cause to you if this status quo is vacated?
No, Your Lordship, here what happened was I have filed appeal regarding the restraining and eviction order. But during the pendency of the eviction and restraining order, during the pendency, the deputy commissioner cancelled the pata of the petitioners. Now it has become another subject, Your Lordship. So again, after approaching this honorable court, after passing the interim order for status quo, they have continued constructing the permanent wall structure. Lordship, here, as of the moment, they have already completed. And thereby we have filed one COP also, Lordship. A contempt petition is pending disposal.
No, I am
Yes,
still
sir.
unable to get the facts, the genesis of the facts.
Yes, Lordship. Lordship, initially, here, if I may, I'm the landowner. I have the right title and interest in this plot of land
Okay,
since
that is not
2010.
the issue here.
Yes, since 2010, Your Lordship. Since 2010. And on a complaint, on perusal of the affidavit that was filed by my learned friend, it is understood that there was a complaint. There was a complaint. A complaint was filed stating that there has been a retaining wall has fallen down. That was the complaint. And so we were given a restraining order. On the restraining order, we have given our reply, stating that we are the landowners, and then there has been no such infringement. And immediately, without giving us a reply, we were given an eviction order, Your Lordship. So I have already stated in my petition also. Now, what are the procedures to process for eviction order, Your Lordship? A party has to be heard first. And then second, there should be adducing of evidence before the deputy commissioner. Your Lordship.
You are before this court by filing a writ petition for what?
For, Your Lordship, when there is a appeal pending before the commissioner, the deputy commissioner again cancelled my pata, stating that they have erroneously issued.
I'm still not getting you.
Yes, Your Lordship.
So Your Lordship, if I may explain. So some land, the petitioner claims that he bought from the landowners. And then based on the purchase from the landowners, the land was mutated into his name. That is the case of the petitioner. And therefore, issuing eviction notices to him for his private land is illegal.
No, did the petitioner come before this court even before this?
Yes, before,
Ah,
yes,
That is
yes.
what I am actually.
Yes, Your
So
Lordship.
during the first round, Your Lordship, during the first round, this honorable court allowed
Director
allowed the
file
petitioner to file an appeal before the commissioner.
Okay.
And in the meantime, till such time, the order of eviction was suspended during
Okay.
that time. So they approached the commissioner. The commissioner has passed orders. And the last order which the commissioner passed, Your Lordship, is in the additional affidavit in the main writ petition. Which I received on 7th of August. So it probably filed on the 7th or 6th of August.
Additional affidavit filed by,
The petitioner, Your Lordship.
let's see. This is 10 July.
I received on 7th of August.
Additional affidavit 10 July.
Yes.
2024.
filed on 7th.
Yes. I received on the 7th of August, Your Lordship, not July.
What does this additional affidavit says?
Your Lordship, is it 7th of August or?
10 July,
No, after that, Your Lordship, there's another affidavit.
8 August.
Yes, my lord.
Yes,
That's the one.
8 August.
Page number 5.
8
Yes, ma'am.
August, just wait, 8 August. Additional affidavit.
Yes, Your Lordship. And this is the last order which has been passed by the commissioner from the documents which have been furnished to us, Your Lordship. At page 10.
At page 10, correct?
Yes, Your Lordship.
Page 10.
Page 10.
This is the last order passed by the
By
commissioner.
the commissioner on the appeal filed by the petitioner.
Okay. Okay.
And Your Lordship, the first page is the recital of the proceedings.
Ah,
And then next page, Your Lordship, page number 11. Last paragraph.
page 11, last paragraph,
In view of the above submissions and observations, this appellate authority deems fit to keep the instant matter in abeyance till disposal of the writ petition by the Honorable High Court, Kohima bench.
To disposal of the writ petition means this. writ-
Yes, my lord.
this
That is the
other
whole
one.
problem, Your Lordship. It should be the other way around. There is an alternative remedy. That remedy has been availed of by the petitioner. In spite of following that alternative remedy, she has filed a writ petition. And in the writ petition, Your Lordship, now, the commissioner has taken note of the fact that there is a writ petition pending,
Ah.
kept the appeal pending till the disposal of the writ petition. That is where we
So,
are,
so the appeal filed by you before the commissioner
still pending.
is still pending.
Yes, Your Lordship.
Okay, yes, yes.
Yes, my lord.
Yes, please.
So therefore, my lord, what I'm saying is this, apart from the fact that 226(3) applies, and therefore the interim order stands automatically vacated. On the merits of the case, Your Lordship, this honorable court allowed her to file an appeal, the petitioner to file an appeal. The petitioner has adopted that approach. The commissioner is insistent over the matter, but has erroneously decided to keep the matter pending because of the proceedings before this honorable court. And that is the most unfortunate situation, Your Lordship. And
Just wait, just wait. Yes, Mr.
yes, madam.
So this order dated 31st July 2024 is the order passed by the commissioner in the second round of litigation.
Yes, madam. In the appeal filed by her, which this honorable court allowed her to do against the eviction orders.
That is the first writ petition.
Yes, my lord.
And
now this is the second writ petition.
second writ petition
Yes.
against whom?
Challenging the cancellation of her pata. The
No,
pata.
Yes, again, that is again confusing.
Yes, my lord.
When the matter is pending before the deputy commissioner,
Yes, my lord.
why should the pata of the petitioner be cancelled?
Your lordship, there are two different proceedings. That is the point, your lordship. this is the nuance which needs to be appreciated by the petitioner, Your Lordship, if I may say so, with all due respect. One is a proceeding under the Public Premises Eviction Act. One is a proceeding under the Assam Land Revenue Regulations Act. Two different actions altogether, Your Lordship.
Let us see the order of cancellation. Let us see.
In the order of cancellation, Your Lordship will see in my affidavit in opposition, in the main petition, there is a sequence of events. That's why I'm referring, Your Lordship, to the
Yes, I'm
affidavit in
also a
opposition.
little confused with the
Yes.
facts.
Yes. This is an affidavit which I filed on the 21st of August, 2024. Your Lordship, has Your Lordship got it?
Which?
The affidavit in
Yeah.
opposition filed by the respondent number 6. Filed on 21/8/2024.
In the writ petition?
In the writ petition.
That date? Was it the moment?
I filed it on 21st of August, Your Lordship. Yes. 21st of August.
Ah.
Has Your Lordship got it?
Yes, yes.
Now, Your Lordship will come to page 25. In my affidavit, I have made detailed statements about how
Yes, wait. Ah.
if Your Lordship will come to page 25 of my affidavit in opposition.
25.
Yes, my lord. This is dated 1st March 2024. Has Your Lordship got it? Page 25. Has Your Lordship got it?
This is approval for cancellation.
Yes, my lord, because Your Lordship will appreciate in terms of the land revenue regulations which we follow, the approval has to come from the Commissioner's office. Allotments, cancellation, all comes from the Commissioner's office. So this is dated 1st March 2024. This is the approval. And this is addressed to the Deputy Commissioner. Approval for cancellation of land pata number 9791 and 9792 in respect of T. Akumba Yimchungar. This is the instant petitioner. And P. Shokum Yimchungar, that is the other petitioner. The other petitioner derives from the first petitioner, Your Lordship, at New Minister's Hill, Kohima, regarding, with reference to the office dated 21st February 2024, and on the subject cited above, I am directed to convey the approval of authority for cancellation of pata number 9791 and 9792 in respect of T. Akumba Yimchungar and P. Shokum Yimchungar, respectively, which were erroneously issued within the premises of Government Quarter number AH 44 at New Minister's Hill, Kohima. Now, Government Quarters AH 44 is the quarter which has been allotted for the accommodation of the Honorable Judges of this Honorable Court, Your Lordship. Further, it is requested to initiate necessary action for eviction without delay. This is for your kind information and necessary action. And this was followed by the actual order, Your Lordship. And the orders are issued by the Deputy Commissioner.
Against this, what steps you have taken?
And
Just to clarify.
not only that, Your Lordship, this approval was followed by the formal order. Next page. Next page. Cancellation order. Yes, 16 March 2024. Pursuant to Commissioner Nagaland approval dated such and such, pata number 9791, 9792, in respect of such and such and such and such, respectively at New Minister's at Kohima, is hereby cancelled with immediate effect.
Timomi, can I understand that this were the orders which are impugned in the first writ petition?
No, Your Lordship, this is subsequent to the first writ petition. This is subsequent to the first writ petition. And then after I filed my affidavit in opposition, bringing these facts on record, Your Lordship will see the prayers in the writ petition. If you can kindly come to the prayers in the writ petition.
I just want to know, what is the fate of this page 25 and 26?
Unchallenged. Unchallenged.
This has not been challenged.
25, Your Lordship.
26.
Lordship,
To my writ petition, page number 52, cancellation order. I have received a cancellation order. I have already challenged, Your Lordship.
This,
Cancellation order. I have
Cancellation-
received a cancellation order by the Deputy Commissioner.
by filing this present writ petition.
Yes, Your Lordship, this present writ petition, I have impugned this cancellation order, the PATA, Your Lordship. I have impugned it.
Where?
In the present writ petition.
Yes, Your Lordship.
Yeah.
Lordship, here, if I may.
No, I'll come to you, I'll come to you.
For
I'll come to
cancellation,
you.
yes.
I still want to
Yes,
actually
Your
understand the facts.
Page 15. Right? Where is? Hmm? Don't
58,
have-
58.
you don't have page 18 in my copy, you want to-
Synopsis.
Yes, madam,
Yes, Your Lordship.
please clarify my
Yeah,
doubt.
yeah.
I'm still confused with the facts. If the deputy commissioner has passed this order 16 March 2024 on the basis of the approval
Yes,
letter passed by the government.
that has not been challenged.
No, passed by the government.
Yes, my lord.
Then why has the deputy commissioner passed that subsequent order?
Because, Your Lordship, the deputy commissioner is the person who issues the formal orders. Approval comes from the government. Formal orders are issued by the deputy commissioner.
Correct.
Yes,
Here the formal order was issued,
yes, my lord.
but there is another order.
The
which
approval order.
Commissioner says that
Yes.
this case will be disposed only after the decision of the writ petition by the honorable.
No, Your Lordship, that is why I was making this submission, Your Lordship. There are two proceedings, two different proceedings altogether. One is under the Assam Land Revenue Regulations and one is under the Public Premises Act. So the commissioner performs dual functions, Your Lordship. In respect of allotment of government land, the commissioner is the final authority for approval, confirmation of allotment, and for cancellation of allotment. That is a different function altogether, Your Lordship. And under the Public Premises Act, the commissioner functions as an appellate authority from orders of eviction which are issued. Two separate functions, Your Lordship. And in this case, Your Lordship, in this case, in the writ petition, the approval on the revenue side has not been challenged. The approval on the revenue side, the commissioner's approval, that is the basis of the action taken against the petitioner. Oh, yeah. How you keeping this whole file with this? In the writ petition, Your Lordship, at paragraph 80, at page 18, if Your Lordship will see the prayer. At page 18. Only the cancellation order dated 16/3/24 has been challenged. Your Lordship, this is just for the purpose of satisfying Your Lordship. Otherwise, my arguments today are only on Article 286.
No. In order to come
Yes,
to
ma'am.
that,
Yes, ma'am.
I have to understand the facts.
Very well.
And the facts are all kichiri.
At page 18, has the Lordship got it? And further, after hearing the parties
Given cancellation order
dated
that is
16/3/24. One 3/24 is not challenged.
which is in fact the basic order.
Yes, my lord, that is the basic order.
So your case is that this order passed by the commissioner, 1st March 2024, and the subsequent consequent cancellation order was passed under the Assam Land Revenue
Yes, my lord.
Regulation.
Yes, my lord. Two separate
And-
actions.
And the subsequent order, subsequent proceedings before the Commissioner Nagaland is under the eviction of.
Under the Eviction Act.
Okay, okay, let me hear you. Yes, yes.
And so
Yes.
so having acted under the land revenue regulations and cancelled the pata of the petitioner, there is no reason for the eviction proceedings to not go ahead. And
So-
even
so-
the appeal
so,
should be
Mr.
heard on
Himobi,
merits. Yes, my lord.
So this eviction, this cancellation orders and the other eviction orders are in challenge in this writ petition.
Yes, my lord, in this writ petition. Yes. So therefore, one point which I wish to make, Your Lordship, this honorable court in the first writ petition allowed the petitioner to file an appeal before the commissioner. That process has not been exhausted till now, and they have filed a second petition.
Because your lordship, my pata was cancelled.
Yeah, I will
Yes.
hear you, I will hear you. Don't get
No,
excited, I will hear you.
Your lordship, no.
I will hear you in detail, but I just want to actually make myself very, very clear on the facts. On the facts, because I'm a little confused on the facts.
So, no, it's not a question of me making Your Lordship confused.
Ah.
What
No,
was,
no, I am confused. I myself, I'm.
since
confused.
my learned friend is
Not you, not
accusing me
you,
of.
Not you.
So what happened in the first writ petition, Your Lordship? In the first writ petition, they challenged the eviction orders. This honorable court found that in terms of the Eviction Act, there is an alternative remedy.
Correct.
There is a provision for appeal.
Ah.
So this honorable court told the petitioner, go file an appeal. She has accepted that. She has accepted that. She has accepted that there is an alternative remedy under the Eviction Act for her to file an appeal. She has pursued that course of action. And that course of action has not concluded till date. Now, the pata may have been cancelled, Your Lordship. The pata may have been cancelled, but that would give her a separate cause of action. But insofar as the action under the Eviction Act is concerned, that must go to its logical conclusion. But that's a different matter, Your Lordship. That's a different
So
matter.
in your challenge to the cancellation order, status quo has been directed to be maintained. Am I right?
Yes.
Not
Yes.
No, just be.
for the commissioner, your lordship.
No, against the cancellation
Yeah,
order
but-
issued by.
Yes.
Deputy Commissioner.
Yes, your lordship.
Status quo order has been directed
Yes, your lordship.
to be maintained.
Yes, your lordship.
Okay, Mr. H. Yes, now I am getting the picture a little.
Yes,
clearer.
my lord.
Hmm,
Yes, my lord.
yeah.
So,
Hmm.
our case is this, Your Lordship. AH 44,
Ah,
Government Quarter 44. It is very clear, Your Lordship. Even the nomenclature is Government Quarter 44.
ah.
It is an enclosed compound. There is a bungalow situated within that enclosed compound. What happened? Part of the wall was broken down and temporary CGI wall was made within the compound, within the judge's bungalow compound.
Ah.
So we submitted a complaint to the Deputy Commissioner. The Deputy Commissioner initiated action under the Public Premises Act. And this led to all these proceedings, Your Lordship. This led to all these proceedings.
But this cancellation order was passed when the matter was pending before the commissioner.
Yes, my lord. Yes, my lord. Yes.
So the question as to whether this cancellation order was rightly passed will be on the merit.
On the merits.
On the merits.
Yes, my lord. On the merits. That will be on merits.
Correct. Okay, yes,
Will be on merits.
yes.
And also, Your Lordship, this honorable court may not be the appropriate forum
Ah,
to go into the merits of that dispute.
correct, yes. That is not for this court to decide,
Yes.
maybe, in my considered opinion.
Yes, ma'am.
Yes.
So as of now, Your Lordship, we're only concerned with the interim order and the mandate of 226(3).
Okay.
And in addition to that, Your Lordship, the other issue which is still alive and very much burning is the alternative remedy which the petitioner is already pursuing, which cannot be kept on hold in terms of the directions of the Honorable Court. File an appeal, appeal should be decided. And again, Your Lordship, on the other day, if Your Lordship will recall, if a matter has been referred to a referral bench, does it mean that the law declared should not be followed? Lordship, just on that point, just so that people don't question what we are doing here in Kohima. So here's a decision of the Honorable Supreme Court, Your Lordship, on this point. A referral may be made, and before the referral is decided by the referral bench, the law declared has to be followed.
If there's no stay.
Yes, my lord, if there's no stay by the referral bench. Paragraphs 32 to 35. Yes, I'll just mention the paragraph. Sure, I will not waste time. I'll just mention the paragraphs. Paragraphs 32 to 35.
No, read. Let me also try to know something. Para 36.
Para 32 at page 35.
32.
Yes.
32. 32.
Yes.
Yes. Yes.
This is also a recent decision, Your Lordship. I have not got the Supreme Court SEC citations yet. The court would categorically emphasize that no litigant should have even an iota of doubt or an impression, rather a misimpression, that just because of systemic delay of the matter not being taken up by the courts, resulting in efflux of time, the cause would be defeated. And the court would be rendered helpless to ensure justice to the party concerned. It would not be out of place to mention that this court can even turn the clock back if the situation warrants such dire measures. The powers of this court, if need be, to even restore status quo ante are not in the realm of any doubt. The reliefs granted in the lead opinion by Honorable K.R. J, concurred with by the 4 learned judges in such and such, is enough on this aspect. We know full well that a 5-judge bench in such and such has referred to a larger bench. However, the questions referred to the larger bench do not detract from the power to bring back status quo ante. That apart, it is settled law that mere reference to a larger bench does not unsettle declared law.
But Mr. Timami, this may not be necessary in view of the law.
It has already been answered. So. But just on the point, Your Lordship, because the argument was being made that since the matter has been referred to a referral bench, the law should not be followed.
No, that is why we were waiting for the outcome.
Yes, ma'am. No, Your Lordship, waiting for the outcome also, while waiting for the outcome, the law declared must be followed. That is the decision, Your Lordship. Unless there is a stay by the referral bench. Unless there is a stay by the referral bench.
But I think that issue is no longer relevant in view of the decision.
Yes, ma'am. In our case, it is no longer relevant, but the principle of law, Your Lordship.
Okay.
The principle of law.
Okay.
There's further elaborations in the paragraphs up to paragraph 35.
Yes.
That's all, my lord.
Okay, ma'am.
Please, Your Lordship.
Yes.
First of all, I beg for apology because I have not gone through the latest judgment of the GLT, Your Lordship. I have not gone through.
That's all right.
Yes, Your Lordship. Yes, much obliged. Lordship. Secondly, here.
You have the copy of the judgment?
No, Your Lordship.
You have the copy of the GLT full bench?
I have not, Your Lordship.
Mr. Timami, can you be generous to furnish a copy?
My book, my lord?
No, a copy, no, GLT. Yes.
It is a book, my lord. Yes. I was fortunate that I got it just last week, Your Lordship.
Okay.
I have not yet, Your Lordship.
Just give it the reference.
I can give it to her.
Take down the reference. Take down the reference.
Yes.
2024, 4 GLT. Full bench, 779. But even apart from this, Your Lordship, the Supreme Court's judgment is clear. I can furnish her a copy of. I give you a copy.
Furnish her.
Another copy. Yes,
This is the one.
yes, you have it. Or you want a
Worship,
copy?
here, I've gone through the Supreme Court judgment. Supreme
Oh.
Court judgment on High Court Bar Association Allahabad versus State of Uttar
The
Pradesh.
full
Lordship.
bench has referred to that.
Agree. Lordship, I have not, on going through, it is understood, your Lordship. I have understood in a very different level, your Lordship.
Okay, okay.
Yes, your Lordship. Here. What I've understood is.
Which
according-
para? Which para?
Your Lordship, para number. Lordship, my apologies, I have just taken off from the net, so it's like.
Take this.
Sorry, check. Yes. Sorry. Lordship, if we see the fact of the case in this present case, your Lordship, this Supreme Court judgment.
Supreme Court or?
Yes.
Full bench?
Yes, full bench. It has to do with Prevention of Corruption Act, where there is a pending trial in the lower court, your Lordship. And then, as per the Asian Risk Surfacing Act judgment, your Lordship, there was a landmark judgment given that an interim order should be, it should last only for 6 months. And so in this.
6 months?
Yes, your Lordship, an interim order. When there's a pending trial, when there's a pending trial before a trial court, before a lower court, your Lordship, that was the observation. And then in this full bench judge, what happened was, this was the fact of the case in criminal cases, your Lordship, with regard to Prevention of Corruption Act, Lordship. Here, nevertheless, they have observed civil as well as criminal cases also, apart from. But the observation that was made here was, here, before the judgment was passed, the full bench judge stated that sometimes in quest of justice, we end up doing injustice. That was the observation that was made. But however, as per this judgment, they did not, the honorable judges, that they did not stated that it is mandatory. They did not give that it is mandatory or directory. They did not give a definite judgment, your Lordship. But however, they have stated that it is noticeable, your Lordship.
Let us see, we have, I think we have come across one. Yes, wait. 779. 779.
Paragraph 29, your Lordship, then paragraph 45.
Yes, paragraph 45. Paragraph 45. Paragraph 45.
Page 797.
Article 226(3) of the Constitution is not a directory provision. Madam? I think we cannot use a different language to
Yes,
introduce
Lordship.
this.
Yeah, Lordship, I have to, my apologies, but since I have just taken off from the net itself, and then on going through the paragraphs and all, it's not telling your Lordship, so that's why I just don't want to take Lordship precious time also going through the, but just want to rely on one.
Madam,
So, Lordship.
let us do justice. We'll give you
Lordship.
time tomorrow. Mr.
Much obliged, your Lordship.
We'll give you time tomorrow.
Much obliged.
Okay.
Yes, your Lordship.
But tomorrow come prepared with all the justice.
I will, your Lordship. I will, definitely.
And I will also take the file and then I will also read the facts.
Yes, your
No,
Lordship.
I'm a little confused with the facts.
Yes, your Lordship.
So tomorrow you highlight me on the law.
Yes, Your
Okay,
Lordship.
let me understand.
I will definitely, Your Lordship, I'll do that.
Mr. Ejmomi,
Yes, madam.
I think it will not be inconvenient tomorrow.
I'll be here tomorrow, Your Lordship.
You'll be
I
here.
I have some other matters after this also tomorrow. If they can be taken up tomorrow,
Okay, okay.
madam.
Tomorrow we take it up as the first item.
Very well, madam.
Okay,
Lordship,
that's the first hearing item.
Yes, madam.
This is in the hearing list,
Admission hearing.
admission.
admission hearing.
Yeah.
This is, for hearing in the IA,
Yes, madam.
IA.
Yes, Your Lordship.
Correct, ma'am?
Yes, Your Lordship.
Mr. Mr. Ejmomi, the learner counsel for the
It's one number 6.
applicant.
Applicant.
In the IA, okay, yes, ma'am. IA 101/2024, okay, not in the mail. There's the counsel for the applicant. And MS Naksantila, learner counsel for the opposite party petitioners.
No,
For the opposite party petitioners, stop. Also heard Mr. Interim, the learned counsel for the state respondents. The hearing remains inconclusive. Listed as the first admission hearing item on tomorrow, that is what will be the 26.
Yes, madam.
26. 26.
Tomorrow's 22nd, madam.
22nd.
Tomorrow's
I'm
22nd.
sorry, I'm too advanced. On 22. No,
10.
okay, on 22/10/2024.
Yes, madam.
So we take it up as the first hearing.
Very well, my lord.
Okay,
My lord.
so ma'am,
Yes, Your Lordship.
you and I, we have actually got some time to go through.
Yes, Your Lordship. Much obliged.
Okay,
Much obliged, madam.
please keep on.
Item number 25.
25 is the same, Your Lordship. This both the petitions are clubbed together.
25 also in IA, okay? In IA,
26 all of that.
in IA, okay, okay.
For admission, item number 26.
Please keep this, huh?
Your Lordship, here,
Just wait, Stephanie. This also, okay. This also, but it's tomorrow. I will. Yes. This is, yes, ma'am.
yes, Your Lordship, state is here to file affidavit, Your Lordship, so kindly grant me 3 weeks' time.
Then why hearing? Is it for hearing?
Admission,
No,
Lordship.
admission.
For admission.
Yes, Lordship. Lordship, if I may just say that the state may make an effort to file the affidavit.
What is your case, Mr. Tushi?
Lordship, I'm praying for posthumous regularization, Lordship.
For posthumous.
Yes, Lordship.
Then the matter is pending before the Honorable Supreme Court.
My lord, I'll make an endeavor to check the status of the case, Lordship.
We give you 3 weeks' time.
Yes, Your
and to
Lordship.
make an endeavor.
Yes, Your
okay,
Lordship.
To file the affidavit, no. MS, yeah, you mean, the learned government advocate is granted 3 weeks' time to file the affidavit in opposition. So, an endeavor shall be made to file the affidavit in opposition on or before the next day. Okay.
Much obliged, Your Lordship.
Obliged, Lordship.
For admission, item numbers 27 and 28.
Your Lordship, these matters also tomorrow.
27, what is this matter, Mr.?
This is about national highways, Your Lordship, without complying with the provisions of the National Highways Act.
I don't know whether.
Your Lordship, if I may, it is already a covered case.
Okay,
It's already a covered case. It will not be too much of a problem. It may not take too much time also. I'm very confident, Your Lordship, with your Lordship's consideration, the matter can be resolved.
Let us try it tomorrow. Okay.
We'll
Let
try
us
tomorrow.
see if time permits.
Yes, ma'am.
Okay. Listed again on
Tomorrow, 22nd.
22nd, 10/20/24. Okay. Yes.
Much obliged.
Much obliged. For admission, item number 29.
May I please the Lordship?
Yes.
Lordship, by an order dated 4/10/2024, Lordship, I was directed by this honorable court to file an affidavit, Lordship.
In IA.
Lordship in IA. Lordship, I'm allowed 2 weeks time to file my affidavit, Lordship.
Have you received the verification report?
Lordship, I have received the verification report and I have placed on 4/10/2024.
But you were directed to file affidavit.
Lordship.
So
Since
there's nothing much remains.
yes, actually, I brought it in the form of a Xerox copy, Lordship, and the photocopy is not visible. So this honorable court has directed to place
So how
the
much time it
original.
would take?
2 weeks time, Lordship.
In terms of the order dated 4/10/2024 passed by this court. Mr. V. Jamogi, the learned government advocate, shall file the verification report received from the office of the Deputy Commissioner Dimapur by way of an affidavit
Lordship,
within,
2 weeks, Lordship.
please make it sure,
Lordship.
within 2 weeks. Listed after 2 weeks.
Lordship, there is interim in the mandate petition.
The interim order part in the main writ petition.
Yes, my
Yes.
lord.
Or next zero word. The interim order passed in the main writ petition shall continue till the next returnable date.
Obliged, Lordship.
Obliged.
For orders, item numbers 30 to 42.
Yes, Mr.
Bless your lordship.
Yes.
Lordship, I'm appearing on behalf of Akampongan for respondent 7 and 8, the newly implemented respondent in WBC 263 of 2024 and item number 40. And then item number 33, 34, and 35. We have filed our Wakalam Nama this morning. Kali Quran, 3 weeks time to file our affidavit.
You are appearing on behalf of
Akampongan for respondent 7.
Akam, okay, just with Akam Pongan for respondent number.
Respondent number 4.
One by one in WPC 25/2021.
253 of 2022.
No, let us go serially.
Oh, okay,
WPC 251. Are you appearing for anybody?
No,
Yes.
no.
You are appearing for?
Lordship,
No. Mr. Impong, you are appearing for?
Lordship, I'm appearing, I'm for the petitioner. I'm appearing in, item number
Okay, you
30.
are for the petitioner.
Lordship.
You are also for the petitioner.
yes, my lord.
Okay, so and you are for the government in all the.
Yes, my lord.
Hmm. So you are for in 253.
Yes,
Let us
lordship.
go one by one, okay?
Yes, lord.
253, you are appearing for respondent. You are appearing for
Respondent number 4, lordship.
4.
Lordship.
In 254, you are appearing for
5.
254, you are appearing for respondent number 4 and 5. In 255, you are appearing for
Respondent 4 and 5, lordship.
4 and 5. In 259, you are appearing for
No, lordship. I'm appearing only on 263 again, lordship.
Item number 40.
Item number 40, lordship.
63.
WPC 263, you are appearing for
7 and 8, lordship.
7 and 8. And in the others, no.
No, lordship.
So what was the direction given in by the last order?
Lordship, by order dated 37/2024, 7/2024, the universities concerned were impeded as a new party response.
Oh, this is regarding
Yes,
that,
fake certificate
right?
case.
Alleged, you let us call it alleged. Alleged fake certificates.
Lordship.
Okay, okay. So what? So whether they have been implemented?
Yes.
Lordship,
And
steps
notice
have
have
been
been taken.
issued.
Yes, notice has already been issued.
But
Steps-
no one appearing.
Yes, except for the Nagaland
Nagaland
University.
University.
Nagaland University.
Yes.
Oh, so,
There are other universities, Lordship.
so these are Nagaland universities?
Yes, my
Yes.
lord, Lordship.
Yes, so then which order?
37/2024, my lord.
37.
Yes.
13 or 30?
No, 30, my lord. 30.
Oh. Ah. So you have intimated. Respondent number 4 and 5 is the university. 4 and 5, you have for university.
Yes, Lordship. In item number 34 and 35.
36. 3, 4, 5. Lordship, I want.
But we will. But okay, Mewar University. Mewar University has filed the affidavit,
Yes, my lord.
correct?
It appears that they have not filed through proper channel. They could have filed through a bleeder, but they've,
No, it's all
as
right.
per the
This court
records,
will accept. This court can accept. It's all right. No problem.
it has been filed directly to the registry, lordship. So there is no bleeder on their behalf.
So have you sent this? Register come respond. Have you filed your affidavit?
No, Lordship.
This court has seen the letter dated 9/9/2024. as well as the affidavit. No, this court has seen the letter dated 9/9/2024 written by the register cum respondent number 4, Mewar University, and the controller of examination cum respondent number 5, Mewar University, to the assistant register within bracket judicial, Gauhati High Court Kohima bench in WPC number 251 slash, what is this, 251 slash 2022 slash 744?
744 might be their issue number, my lord.
251 slash 2022, 2022, as well as the affidavit filed by the, register, Mewar University, and the controller of examination of the said university. Stop. It is however seen that the letters and the affidavit filed by the officials of the Mewar University is not in accordance with the notification number 89 dated 27/2023 issued by the Gauhati High Court. Stop. Stop. Registry to take up the matter with the register, Mewar University, and the controller of examination, Mewar University. And bring the notification dated 27/2023 to the knowledge of the said officials, so that the affidavit can be filed by the said officials of the university in accordance with the notification number 89 dated 20 July 2023. So, Mr. Your good name?
Individual.
Mr. So-and-so, learned counsel appearing for
On behalf of Akampongan.
Akampongan, learned counsel appearing on behalf of Mr.
Akampongan.
Akampongan.
Yes, Lordship.
He is the standing counsel, Nagaland University.
Yes, Lordship.
The learned standing counsel appears for the learned standing counsel appears for Nagaland University. The learned standing counsel, Nagaland University, submits that. What is your prayer?
To file affidavit in opposition.
Submits that 3 weeks' time may be given to the said respondent to file affidavit in opposition. Prayer is allowed. Listed on.
Lordship, in respect of item number 36 to 42, except the item 40, which my learned friend is appearing. Here the notice is awaited, Lordship. The university is different here.
Not Mewar.
Not Mewar.
So it has to be seen one by one, I think.
From item number 36 to 42.
What was the last line? Affidavit in opposition. Stop. Insofar as,
The WPC
insofar as,
from item number 36,
so insofar as WPC 259/22, 260/2022, 261/2022, 262 also,
Lordship,
262/2022,
264.
264/2022, 265/2022. Okay, that, na?
Lordship.
And 265 slash, last and. Notice upon,
Service upon respondent number 7 and 8 is still awaited.
service upon respondent number 7 and 8 is still awaited.
Lordship, if the registry may be directed to track consignment, Lordship. We have taken steps on 4/9/2024.
The registry to track the consignment records, report affecting the service of notice upon the respondent number
7 and 8.
7 and 8 in the said writ petitions. Okay.
Lordship, here in item number 31, there's an interim order
Okay.
that may be kindly considered, Lordship.
The interim order passed in WPC 114/2022.
Except here, Lordship, there's no interim.
Shall continue till the next return will be. Okay. Okay.
For hearing item numbers 51 and 52.
This is.
May I please,
Yeah,
Lordship?
Mr. TB, I think we will have to list this some other time.
Lordship, Lordship, this is a part third matter. If your Lordship may kindly recollect this regarding that consultant technical and horticulture specialist at CS Mitsupima, your Lordship.
Not be released from Portland.
Lordship, then Thursday,
Thursday, and because Thursday is not a good day,
Lordship.
but we can give a try, and if maybe if not possible, then we release from Portland.
Lordship.
Listed as a Portland item again on. What is Thursday?
Thursday will be 24, your Lordship. 24, 24.
Lordship, 24, it's not be possible for me because the DPA part, election. DPA, Timor part.
You are a member of Dimapur Bar.
Yes, Lord.
So what to do?
I'll leave it to your Lordship.
If it is not Thursday, then we have to release.
Lordship.
Or tomorrow, it will be.
Tomorrow, it may not be possible.
Tomorrow, there is another part third matter regarding that lookout.
That is also uncertain.
This is Lordship. Then Lordship may release it from part third, it's okay. We can then.
Due to paucity of time, ma'am? Due to paucity of time, the matter could not be taken up. Listed after 2 weeks,
Lordship,
released from part third.
Lordship. Obliged, Lordship.